Yeah, twice. That's right. Oh, you heard, you saw what I wrote back. Said, oh,
We got a saving already, DVC.
I'm gonna get it back. Well, actually, make it a concept.
Boy, it's gonna be a good one.
Clarification. That's right.
Good afternoon. Good afternoon. I'd like to call the Finance, Ways and Means Committee to order for May 3rd, 2021. Mr. Clerk, would you please call the roll?
Representatives Campbell, Camper, Crawford, Faison, Freeman, Gant, Garrett, Gillespie, Hawk, Hicks, Lamar, Lamberth, Lynn, Miller, Ogles, Sexton, Shaw, Sparks, Todd, Whitson, Williams, Wendell, Zachary, Vice Chairman Baum, Chairman Hazelwood. Madam Chairman, you have a quorum.
Thank you, Mr. Clerk. Are there any personal orders or announcements? Seeing none other, I have one. We thanked a number of people in sub, and we'll be thanking a number of people again at the conclusion of our work. But I just want to take a minute to recognize the intern who's worked with finance this year. She's in the audience. She has been faithfully here watching this, and she said she even found it interesting and riveting. So, hey. But please give a hand to Ava Pacchiana and say thank you for her hard work. And just to make some of you feel bad about your college credentials, Ava is completing her junior year at Vanderbilt with a 4.0. She's a Peabody Scholar. She has a double major, and she has a Bloomberg scholarship for a summer internship in New York. So we're very fortunate to have somebody so well endowed with intelligence serving on this committee. So thank you, Ava. We have 13 bills on our regular calendar. We're going to take up the regular House calendar first, then we'll take up the TASER calendar, the regular sub calendar plus the addendum, and then those bills that Chairman Hicks just brought from behind the budget. So again, I hope you held on to paper calendars from the previous event, as we did not have time to reprint those, and we wanted to save some trees. So item number 1 on our calendar is House Bill 357 by Chairman Curcio. Chairman Curcio, you're recognized, and you do have a motion and a second.
Thank you, Madam Chairman and committee members. This bill, as amended, would simply say that an employee of the 21st Judicial District who transfers to the same position in the 32nd Judicial District as of September 1st, 2022, must retain the same level of salary and benefits they have now.
Are there questions for the sponsor? Question has been called. Any objections? Seeing none, we're voting on House Bill HB 357, moving to calendar and rules. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 357 will be heard next in calendar and rules.
Thank you, Chairman and committee. Do you want us to stay for our bills later or come back?
You can feel free to do either, but if we come to you and you're not here, you'll get moved to the Hill. So
right. Yeah, no problem. I didn't
at
know if
your
you wanted to do
discretion.
it. Got it. Okay. Thank you.
Next on our agenda is House Bill 1028 by Chairman Kumar. Well, we have a motion and a second, but I don't see the sponsor, so to the Hill. Chairman Kumar, I mean, you are so close to having to wait to the bottom. But you are recognized. We had a motion and a second even before you were here. Your power is so great.
Thank
So
you.
if
Thank
you would
you.
please explain the bill to us.
Thank you for your kindness. This came from the Chronic Disease Prevention Task Force, and House Bill 1028 allows a municipality, county, or a county having a metropolitan form of government by resolution or local ordinance to prohibit the use of smoking, vaping, or both in public parks, playgrounds, greenways, or public property that is accessible to minors, that is people below the age of 21. The enclosed buildings are excluded.
Thank you for that explanation. Are there questions of the sponsor? Seeing none, without objection, we're voting on House Bill 1028. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1028 moves on to calendar and rules.
Thank you, Chairman and Committee.
Item number 3, House Bill 1515 by Representative Cochran. Representative Cochran, you're recognized, and I did hear a motion and a second. I believe we do have an amendment on this bill. Is that correct?
Thank you, Madam Chairman. I believe we're going to add Amendment 7987.
That's the one I show. We have a motion and a second on the amendment. The question has been called on the amendment. Without objection, we're voting on the amendment 7987. All in favor, please signify by saying aye. Any opposed? The amendment is hereby attached. And Representative Cochran, if you would explain the bill as amended, please.
Thank you, Madam Chairman. This bill essentially fixes the hotel motel tax formula from this point going forward, setting it at 4% at both the city and county level if they are enacting a new hotel motel tax. It also protects anything that has been passed to this point, if anything that is different from 4%. But I will yield to any questions.
You've heard the sponsor's explanation. Are there questions? Seeing none, I'd like to thank you for this bill. Hopefully that will cut down on the number of bills dealing with this issue going
Yes.
forward. So thank you very much. We're voting on House Bill 1515. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1515 moves on to calendar and rules.
Thank you, Chair, Lady and Committee.
Item number 4 is House Bill 157 by Representative Beck. We have a motion. We have a second. Representative Beck, you're recognized.
Thank you, Madam Chair. This is my bill to extend the tax recapture policy for the Nashville Predators. The policy allows these funds to be reinvested into the arena for renovations and repairs to keep it a first-rate arena, and not only in Tennessee but around the country. And with that, I'll be happy to take any questions, Madam Chair.
The question has been called. Any objection to calling the question? Seeing none, we're voting on House Bill 157. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 157 moves to calendar and rules.
Thank you, Madam Chair and Committee.
Item number 5 on our calendar is House Bill 798 by Representative Chisholm. I have a motion and a second. Representative Chisholm, you're recognized.
Thank you, Madam Chair and Committee. This bill as amended, it affords local government 4-year statute of repose after the completion of an improvement to a light railway. With that, I stand by for any questions.
You've heard the sponsor's explanation. Anyone have questions? Question has been called on the bill. All those in favor, or without objection, all those in favor, please vote aye on House Bill 798. Any opposed? The ayes have it. House Bill 798 moves on to calendar and rules.
Thank you, Chair and Committee.
Item number 6 on our calendar is Representative McKenzie, who's been more than ready. You tried to jump in front of Representative Chisholm, I noticed. We have a motion and a second. Representative McKenzie, you're recognized.
Thank you, Madam Chair, and I was hoping no one saw that. This bill as amended does two things. It utilizes alternative methodologies for the calculations on how child care facilities are reimbursed, and it also allows for a combining of operation, a better efficiency of scale that they can combine their organization, their accounting, cafeterias, things like that.
All right, thank you for that explanation, and thank you for the bill. I know childcare is an issue that we are all recognize the importance of, and we have work to do in that arena. So thank you for this portion of that. Are there questions of the sponsor? Question has been called. Any objection to the question? Seeing none, we're voting on House Bill 1509. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1509 moves on to calendar and rules.
Thank you, Madam Chair and
Representative McKenzie. Item number 7 on our calendar. A motion and a second. Representative Stewart. Representative Stewart, you're recognized on House Bill 1297.
Thank you, Madam Chair, members of the committee. This just creates a fund. It mandates nothing. It creates a fund that municipalities can use to combine public and private monies to study the involvement of juveniles in homicides and prostitution. And it goes to this whole issue we have in Nashville and other cities, such as Knoxville, Senator Massey's city, where you have a combination of violence and human trafficking. We want to study that and get to the bottom of it.
Leader Lamberth, you're recognized.
Thank you, Madam Chairman. And if you don't mind, why can't they just do this already? Why is there a need for a state law change to allow municipality to be able to do this? I mean, they do this with so many other things already.
It's a good question, and here's the answer, because what makes this different and why it is not necessarily authorized under a particular municipal code is that it allows the combination of public money and private monies. And so, Leader, if you picture yourself, if you're going to a private individual and you're trying to get them to participate in this process, you want to have a clear, decisive statement by the legislature. This is lawful. It's been authorized. You're not going to have any follow-on problems, lawsuits, et cetera. So that's why we're doing this, so that it's not something that people have to cobble together by pointing to the charter and doing this and that, but it's just an absolute clear mandate from us.
Leader Lamberth.
Thank you. And what would happen with the information that comes from this? Would they bring back proposals to this body? Would they use this for local programs to better direct them on how to help juveniles that might be in this situation? I mean, what would kind of the purpose of that be?
Here's my hope. I mean, this is an era where there's been great bipartisan agreement and a lot of movement in the legislature. A lot of bills this year have been passed to address these problems. And so I would hope, if we bring science to bear, bring the best minds on this, that we'll find additional ways that Tennessee can kind of lead the charge. Of course, ultimately, that'll be up to the discretion of the elected decision makers. And I can't say what ultimately will occur. I actually have no particular end desired, except my experiences, and I think many of you have experienced this. It's surprising how often bringing together scientific experts in this case on criminal behavior, criminology, may yield information that we can use in this body, But the point is, first, the question is you study it, then you look at what the information shows and you take steps accordingly. It maybe we find we've done most, that we're at best practices. I actually don't know. But I do think it's an area, I'll tell you why I'm hopeful about this. It's a big problem. It's a big problem in urban areas in this state in particular. But I do think it's pretty clear this legislature that we have right now is kind of ready to stand up and do whatever it takes to address these problems. So it's really a matter of, where we want to aim. It's not a matter of the will. It's a matter of what we're doing. And so I'm hopeful. I think it's a real break we're having. I think it's one area where Tennessee's making a lot of forward progress. And so I'm just hopeful we can, make sure we do everything we can.
Thank you. I just want to make sure nothing of this nature would slow down some of those initiatives that are already out there and being discussed. So it doesn't sound like that's your intention. Thank you very much.
Chairman Williams.
Thank you, Leader Kemper. Representative, we had a bill earlier come through finance that allowed for a local municipality to be the throughput for a sales tax stipend for a local entity downtown for safety and cleanliness. I guess my concern about this, and when I heard it in local earlier, is the concern is that we're going to create something that it was intended for the private sector or nonprofits to do. And so I guess what would be the benefit? Are you looking to try to form some quasi-governmental hybrid so in the future we could tax local businesses and send that money to be spent maybe in Metro?
Yeah, of course, being for Davidson County, we know all about that. The bottom line is no. I mean, this is designed to allow, and the reason I think it matters and the reason it's not something, or the reason it adds an efficiency is it allows the decision maker, the elected leader, to say, look, we're going to study this in our area, and depending on where you are, I'm going to bring to bear the resources that we have at our disposal, whether they're not-for-profits, private individuals, or any resources my city council will give me, and we're going to study this problem. But this doesn't authorize and certainly doesn't anticipate the creation of a body or any sort of new entity, nor certainly does it, give rise to any taxing power. And it's not my interest. I really believe this is about, we have dynamic political actors. It's giving them a tool they can use if they want to dig into this, and it's at their discretion. So I mean, the elected leader, maintains the power over this.
All right. Any further questions? Seeing none. We're voting on House Bill 1297. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1297 moves on to calendar and rules.
Thank you, Chair, lady, members of the committee.
Thank you. Next on our agenda, item number 8 is House Bill 1534 by Representative Weaver. Representative Weaver, you have a motion and a second. You are recognized.
Thank you, Chairman. Thank you, members. Let me grab my spot here. This is a great bill. Thought I'd wake you up. This bill, we have an issue with recruitment and retention of effective teachers for our children. And this bill, as amended, House Bill 1535, helps address the issue of retention and recruitment and retention by requiring the state board to approve a process that gives school districts the ability to create teacher training
Representative
programs.
Weaver, you said House Bill 1535, but I believe we're on House Bill 1534.
That's right. Sorry, my bad. It's the good one. It's still good. It's still good. Thank you. Let me rewind and let's start all over again. This bill gives our state board to approve a process to give our school districts the ability to create teacher training programs that provide content knowledge for additional endorsements at a local level. Under the bill, teachers would receive the training needed to add an additional endorsement without being required to enroll in an educator preparation program. The bill does require a teacher to take an assessment to add an endorsement unless they have been teaching for more than 6 years and received above expectation or significantly above expectation. In other words, a level 4 or 5 on their most recent evaluation. And of course, this bill exempts the part it would not apply to a teacher if they are adding an endorsement in grades K through 3 based on the Tennessee Literacy Success Act that we passed during our special session. Again, the goal of this endorsement pathway created under this bill is to increase retention of high-quality educators by providing additional flexibility at a local level, thus benefiting our students, benefits our teachers, many of which have come through a horrendous year through COVID. And also this would prevent teacher burnout. It would give a teacher an opportunity to try another pathway. Again, there's checks and balances in the bill. There are things that there's bars for you to achieve. I think it's a great way to help our teachers and ultimately help our students.
I believe Representative Shaw had a question.
I did, Madam Chair. Thank you. I guess I thought, would this training be above the normal training that is provided for teachers?
Representative Weaver.
This training presents, again, the checks and balances are they have to have been teaching 6 years or more. They've already taken a praxis test. They've already been teaching. They're already qualified. And they'll be highly evaluated by their local LEAs. So the checks and balances are already in place.
Thank you.
Representative Shaw.
Thank you, Madam Chair. I still didn't get the answer I was looking for. I'm trying to see, are we doing something with teachers that I thought we had a training program,
Mhm.
but I guess what I'm wondering, are we looking to do something for a group of teachers that we have not been doing or not? I just didn't quite understand it. And thank you for letting me ask that, Madam Chair.
Representative Weaver.
Well, as I understand what you're asking, Representative, the teachers that this would involve are teachers that are already in place. They've already been tested. They've already been evaluated. These are teachers who want to seek another endorsement. So they would be highly qualified, and it gives our LEAs the flexibility. And I'll tell you another thing that really helps is our rural areas. They've already got these teachers in place, and so they can utilize these teachers as well. Does that help? Maybe somehow?
I believe, Representative Shaw, that this bill allows teachers to change their field. They're already teaching, they're certified, but say they're teaching physics and they're tired of it, they're burnt out, they'd like to change to chemistry or some other related field, and this would enable them to do that. That's my understanding of the legislation.
Well said.
Leader Lambert.
Move previous question.
Question has been called. Any objections? Seeing none, we're voting on House Bill 1534 by Representative Weaver. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. 1534 moves to calendar and rules.
Thank you, Chairman. Thank you, member.
Next on our calendar is House Bill 139, item number 9 by Chairman Baum. Chairman Baum, you're recognized.
Thank you, Chair Lady Hazelwood. This is a bill to
We have
help.
a motion and a second.
Thank you. This is a bill to help foster children as they age into adulthood, and I'm honored to carry this on behalf of the administration. It helps foster children in two ways, in two parts. The first part expands the eligibility for the Hope Foster Child Tuition Grant. Currently, the foster child has to have spent 1 year in DCS custody between the ages of 14 and 18. If you move into DCS custody for the first time after age 17, you can't get that 1 year in order to be eligible. This bill allows those foster children to become eligible if they don't have that year because they entered custody after they turned age 17. And the second part of the bill helps foster children as they go off to college. It sets up a foster child liaison program. The liaison works with the foster child at colleges, serving as a mentor and an advocate in order to enhance retention rates and graduation rates.
You've heard the sponsor's explanation. Are there questions? Representative Sparks.
Dr. Baum, just want to ask you, maybe the leader, I mean, typically what's happened to someone in foster care when they turn 18? I mean, what's that next step if they're not going to college?
I suppose that they have options to go to college or not go to college, but this helps them with the ability to finance college by making them more apt to be eligible for this foster child tuition grant. Again, it allows individuals who are over the age of 17 when they move into DCS custody to be eligible, and hopefully this financial support enhances their ability to go to college.
And that would include a TCAT, I'm assuming?
Yes.
Okay. All right. Thank you.
Question has been called. Any objection? Seeing none, we're voting on House Bill 139. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 139 moves on to calendar and rules. Number 10 on our calendar today is House Bill 612 by Leader Gant. Leader Gant, you're recognized. You have a
Thank you.
motion and a second.
Thank you, Madam Chair. This is a treasurer bill, and what this does is this bill authorizes the state treasurer to inquire with local governments and volunteer fire departments about establishing a length of service award program known as LOSAP. And with your indulgence, Madam Chair, I need to read into part of the record, if I could.
Certainly.
No, I'm sorry. I'm on a different bill. So it's that kind of day. I'm sorry. I yield back. I'm sorry.
All right, are there questions from Leader Gant after hearing his explanation? Seeing none, we're voting on House Bill 612
It's on the next bill.
by Leader Gant. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 612 moves on. Item
sorry.
number 11 on our calendar is also by Leader Gant. Leader Gant, you have a motion and a second. You're recognized.
Thank you, Madam Chair. This is the bill I need to read into the record, so I got a little ahead of myself. So what this legislation does is this proposed legislation includes proposals from regulatory boards and their directors, addresses a recent lawsuit, creates a deduplication exemption for certain licensees, and allows for easier access to reserve fund accounts for enumerated uses. And with your indulgence, if I can read into the record, Madam Chair, after considering and discussing, the department will set an internal practice that regulatory boards reserve funds will strive to maintain 25% of the previous fiscal year's total budget for any given program. This calculation would allow the department to approve spending for strategic items related to a given program/industry while protecting against market volatility and fluctuations and protecting the sustainability of each program. Any reserve spending would be for specific items related to the program from which the monies came and must be approved by the commissioners from TDCI and Finance and Administration. Additionally, funds would not be spent in a way that would put a program at risk of violating its self-sufficiency requirement found in TCA 4-29-121. Thank you, Madam Chair.
You've heard the explanation. Question has been called. All those in favor of House Bill 7? All those in favor of House Bill 780? Please signify by voting aye. Any opposed? The ayes have it. House Bill 780 moves on to calendar and rules. Item number 12 on our calendar, House Bill 1383 by Chairman Todd. Chairman Todd, you're recognized. We have a motion and a second. Please tell us what the legislation does.
Thank you, Madam Chair. What this does, it allows law enforcement officers who have been retired for 9 months or more the ability to return to a law enforcement agency without losing any of their retirement benefits. And there are certain restrictions on this. And the only reason this is really in this committee is because it is permissive. It will have a cost if the law enforcement agencies choose to hire these folks just as they would hiring anyone else off the street.
You've heard the sponsor's explanation. Seeing no questions, we're voting on House Bill 1383. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1383 moves on to calendar and rules. Lucky number 13 on our calendar is House Bill 869 by Chairman Zachary. Chairman Zachary, you're recognized.
Thank you, Madam Chair. Members, this legislation is a result of the ad hoc committee that was put together this summer by Speaker Sexton and Lieutenant Governor McNally to study executive powers during a state of emergency. Fiscal summary is not significant. There's 7 different sections to this bill. There's multiple members of this committee that were part of that ad hoc committee. I can go into more detail if you wish, Madam Chair, but I'll stand ready for questions.
Question has been called. Seeing no objection to the question, we're voting on House Bill 869. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 869 moves on to calendar and rules.
Thank you, Madam Chair and Committee.
That completes the full calendar, and we're going to make a change on the fly. We will next take up the TASER calendar, but after that, we will take up the behind the budget calendar before we go to the regular sub-calendar. So for those of you who are waiting for your turn, just note that change. All right, on the TASER calendar, item number 1 is House Bill 353 by Chairman Hicks. Chairman Hicks, you're recognized. You have a motion and a second.
Thank you, Chair Lady and members. This House Bill 353, which has been worked on for many years, it seems like now. I think Bud's been working on this. Representative Hulse has been working on this for about 5 years. So This simply would ask allow Tasker to conduct a feasibility study of creating a gold bullion depository in the state.
Are there questions? Seeing none, all those in favor of House Bill 353, please signify by saying aye. Any opposed? The ayes have it. House Bill 353 moves on to calendar and rules. Item number 2 on our calendar is 1593 by Representative Miller. Representative Miller doesn't seem to be present, so we'll move that to the Hill. Item number 3 is House Bill 1344 by Representative Ogles. We have a motion and a second. Representative Ogles, you're recognized.
Thank you, Madam Chair. Members, this bill would allow and require TASER to do a comprehensive study of childhood obesity and the socioeconomic impact it has on our state and various state departments.
You've heard the explanation. Are there questions? Seeing none, we're voting on House Bill 1344. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1344 moves on to calendar and rules. Item number 4 on the calendar is House Bill 1389 by Chairman Todd. Chairman Todd, you're recognized. You do have a motion and a second.
Thank you, Madam Chair. This bill directs Tasker to do a study on those TWRA and TDEC managed state resources that are being used for recreational activities such as paddleboarding, canoeing, tubing, and kayaking.
You've heard the explanation. Any questions? Seeing none, we're voting on House Bill 1389. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1389 moves on to calendar and rules. That takes us back to item number 2. I believe that Leader Camper is going to present House Bill 1593. Leader Camper, you're recognized.
Thank you, Madam Chair.
We have a motion and a second.
Thank you, Madam Chair. Madam Chair, what 1593 do is directs TASER to do a study on the issuance of contracts with businesses and firms owned by African Americans and report back to the General Assembly and the Governor.
You've heard the explanation. Are there questions? Seeing none, we're voting on House Bill 1593. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 1593 moves on to calendar and rules. That brings us to the behind the budget calendar. The first item on that calendar is House Bill 1047 by Speaker Sexton. We have a motion and a second. Speaker Sexton, you're recognized.
Thank you, Madam Chair. What I will say, members, is this is the Truth in Sentencing Bill. This does not take away the judicial discretion from the judges or a jury. And so whatever the range is within the criminal statute based on the type of criminal you are or the type of felony you commit, whatever that range is for crimes, and it's listed in the bill, it's A through double E, whatever crimes historically against women and children, if the judge gives you 9 years based on whatever range and offender class you are, you serve 100% of 9 years. That's it. That's what this bill does.
Heard the sponsor's explanation. Leader Lamberth, you're recognized.
Thank you, Chairman and Speaker. Thank you for sponsoring this bill. And I know you've worked for a long time to be able to get this out there in a good form. I mean, it's part of a criminal justice reform package. I mean, obviously, sometimes we reduce sentences and sometimes we increase sentences. And specifically, members, if you'll look at the crimes that are listed within this bill, and these are some heinous offenses. I mean, these are the type of things that if someone's been on probation over and over and over again, and a judge finally says it's time to go away and go to prison, then it needs to be a very definitive time period, and it needs to be enough time that hopefully it sends a message loud and strong that we're not going to put up with this type of behavior. So, Speaker, thank you for being a champion for these issues, and I'm confident that it will make Tennessee safer tomorrow than it is today. Thank you, Speaker.
Any other questions, comments? Seeing none, we're voting on House Bill 1047. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1047 moves on to calendar and rules. Next item on our calendar is House Bill 430 by Leader Lamberth. Leader Lamberth, you're recognized. You have a motion and a second.
Thank you, Madam Chairman. And as I've described this bill in the past, this merely fixes something that should not have been on the books to begin with, where someone who commits the offense of facilitation of rape is eligible for parole at 30%. And just like the last bill, this would significantly increase the sentence so that someone commits that heinous crime will serve some actual time.
Thank you for that explanation, Mr. Sponsor. Any questions? Seeing none, we're voting on House Bill 430. All those in favor of House Bill 430, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 430 moves on to calendar and rules. Next on our agenda is item number 5 on your calendar. It's House Bill 948 by Chairman Boyd. We have a motion and a second. Chairman Boyd, you're recognized.
Thank you, Madam Chairman, committee.
And I think, Mr. Chairman, we have some work to do. I believe there's an amendment that we need to withdraw, Amendment 7935.
I don't know if it's been withdrawn. I know there's another amendment that's being added on.
We need to withdraw this one.
Okay.
So without objection, Amendment 7935 is withdrawn. Then we have an Amendment 8138 that needs to be added onto the bill. And we have a motion and a second. We have a motion and a second. All those in favor of Amendment 8138, please signify by saying aye. Any opposed? The ayes have it. And 8138 is now attached to the bill. And Chairman Boyd, if you could now explain the bill as amended.
Thank you, Madam Chairman. House Bill 948, as amended, brings some reform to Tennessee's certificate of need process. It essentially makes the process quicker. It reduces cost. It streamlines the process. It eliminates some of the different protectionist aspects of certificate of need. It creates more flexibility to allow some entities that have that are operating under certificate of need that relocate within a small distance, be able to relocate without having to go back through the certificate of need process. But most importantly, it requires the HSDA executive director to develop a plan to merge certificate of need with the healthcare licensor into a single agency, and that plan shall be submitted to the General Assembly no later than January the 1st of 2023. And I can take any questions, Madam Chairman.
Thank you, Chairman Boyd. Are there questions for the sponsor? Seeing none, we're voting on House Bill 948. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 948 moves on to calendar and rules. Thank you,
Madam
Chairman
Chairman.
Boyd. Next on our agenda is House Bill 419 by Chairman Sapicki. I don't see the chairman, so we will move that to the Hill. Item 9 is also Chairman Sapicki, so that too will move to the Hill. That brings us to item number 15 by Chairman Doggett. We have a motion and a second. Did I skip it? Okay. Chairman Doggett, thank you for fighting off Chairman Curcio from the podium. I promise Chairman Curcio, we will get back to you immediately after Chairman Doggett, but I'm glad that you all worked that out peacefully among you. So Chairman Doggett, you're recognized. You have a motion and a second.
Thank you. We're on House Bill, 904. And what this does is it allows the District Attorney General to petition for a order of protection for victims of sexual offenses and witnesses of those against the defendant as they go throughout the court process.
You've heard the explanation. Are there questions? Seeing none, we're voting on House Bill 904. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 904 moves on to calendar and rules.
Thank you very much.
That brings us back to Chairman Curcio, who is impatiently waiting. House Bill 744.
Thank you, Madam Chair. Thank you, committee.
We have a motion and a second.
Thank you. And do I need to put the amendment on or?
We do.
Okay, the amendment is coded 8120.
We We have a motion and a second. All those in favor of Amendment 8120 being added onto the bill, please signify by saying aye. Any opposed? The amendment is attached. Chairman Curcio, now if you could explain the bill as amended.
Thank you, Madam Chair. Yes, this bill would create a matching grant fund to create victims' safe spaces inside county courthouses. Many of you may already have a courthouse that's equipped with a victims' safe space, but if they're not, they can apply to draw down some dollars from this. The amendment takes the state out of the equation, and it will be funded out of existing revenues with the District Attorney's General Conference.
Thank you, Mr. Chairman, for the explanation. Questions? Seeing none, we're voting on House Bill 744. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 744 moves on to calendar and rules.
Thank you, Madam Chair and Committee.
Next on our agenda, item number 16, House Bill 1130 by Chairman Farmer. Chairman Farmer, you're recognized.
Thank you, Madam Chair and committee members.
You do have a motion and a second, and I believe we have an amendment that we need to add to this bill.
We do. And that is amendment to 8130.
That's what I show. We have a motion and a second. Does the amendment make the bill, or would you like to describe the amendment separately?
It does make the bill.
All right, well, let's get it
Madam Chair.
on the bill, and then we'll let you describe the bill as amended.
Okay.
All those in favor of Amendment H130, please signify by saying aye. Any opposed? The ayes have it. 8130 is attached to the bill. And now, Chairman Farmer, if you could explain the bill as we've just amended it.
Okay. And thank you, Madam Chair. And members, I've spoken to a lot of you all, whether it be through committee or out in the hallway. What House Bill 1130 did was it created the 3 Chancery Court positions in the East, Middle, and Western districts of here in Tennessee, appointed by the governor, and then they're going to be on popular vote when the governor runs again in 22. What this amendment does is it changes it from trial court positions and creates a court of special appeals, just to hear those same issues that were in the original bill, statutory issues, constitutional issues against the state, and that court would then have original jurisdiction. So how this would work is the governor would appoint, and then they would run on retention ballot every 8 years. So with that explanation, I'll take any questions.
Are there questions? Leader Lamberth.
Thank you, Madam Chairman. And Chairman Farmer, thank you very much for working on this issue. I know this has been a difficult issue to try to resolve in a positive way. And it sounds to me like this is almost kind of the perfect resolution to this, because it's exactly the way we do other appellate judges. So, I mean, it's appointments with retention elections. It puts it right in line with everything else we do. And these are some of the most important issues that are going to come up before a court. You really need some specialized judges that handle these on a daily basis. You've got to have that, really, I guess, tried and true individuals that are going to be able to give some consistency to these issues so that we know what to expect here in the legislature and so that the people of Tennessee know what to expect. So again, thank you for working on this. Thank you for this amendment. It certainly will give, I think, a much broader ability for folks to be able to really make sure that the laws that are passed here get a fair shake in court. It's not going to, shade it one way or the other, but it certainly will create some experts there to be able to hear these cases. It's better than the other version as well, in multiple different ways. I want to say this too. It has just been kind of disturbing over the years to see how folks will try to kind of cherry pick where they want to file cases. And you and I see that all the time in the courtroom, where folks will try to, pick their judge to try to get the result that they want. We just want judges to be fair. And we in the legislature have the ability to decide venue and jurisdiction and all of that. So that's what this sets up, as a truly fair process, probably for the first time in a long time. So thank you for leadership on this issue.
And Madam Chair.
Chairman Farmer.
May I respond? And thank you for that, Leader Lamberth. I had, the original bill looked like and walked and talked a lot like a court of appeals. So I think this is a much cleaner version. I think it gives a fair representation to those eastern, middle, and western districts of the state, instead of in one portion, whether it be east, middle, or western district. I think it gives a fair representation to the values of those folks who live there. So thank you for those comments.
Representative Shaw.
Thank you, Madam Chair. Ms. Ponce, I just wanted to ask you, is there a backlog in this area right now Are we fixing a backlog maybe?
Madam Chair.
Farmer.
And thank you. And it's certainly a possibility. I'm not aware of one right now in this particular venue, but courts across the state are certainly backed up, and there very well could be one, and this would certainly help that if that's the case.
Thank you.
Other questions? Seeing none. Oh, I'm sorry. Representative Lamar.
Thank you, Chair Lady. You probably didn't see me because I was on the side, so sorry about that. Thank you to the sponsor. I just have a couple of questions. There was a comment that this creates fairness, but we see that the governor will initially appoint the judges. Am I correct? Initially.
Representative Chairman Farmer.
That's correct.
Representative Lamar.
Thank you. So my concern is that our governor is elected through partisan elections, and they get to appoint these judges. So I'm concerned that there isn't fairness because he could pick judges who align with many of the issues that he's pushing. Am I correct?
Chairman Farmer.
That could certainly be the case either way, whether it's a Democratic governor or a Republican governor. Sure.
Okay. Can I continue?
Representative Lamar.
Thank you. So we also elect chancellor judges on the county level. What happens to them if we create this new statewide chancery court?
Chairman Farmer.
And one thing I should have said to begin with, once the governor selects this appointment, we, the General Assembly, get to confirm that. So we're going to be able to bring the voices and values from our own districts to that particular appointee and ask that appointee, potential appointee questions. As such, to go with your question with regards to local chancery courts, I think this is a separate jurisdictional issue here. These folks have jurisdictional issue just like the Court of Appeals does as of now, except we're just narrowly tailoring this to be constitutional issues with regards to the state.
So my question is that, say for example, the legislature passed some election bills last year, and the chancellor decided that we needed to open up no excuse absentee voting just for the August election because of the pandemic. Would this new chancery court supersede her decision if she rules on that? There was a Davidson County chancellor who ruled that we have to do no excuse absentee voting in the August election. She made a decision, and the secretary and everyone else had to follow that. With this new chancery court created, would it supersede her decisions?
Chairman Farmer.
And thank you for that question. Now, this is an appellate court. We're not creating a chancery court. So that's in the old amendment. Okay, that was a trial court.
Okay.
This is separate. This is an appeals court. Next level up. They would take and look at specific issues just as that. If there's an issue with that, yes, they could pluck that out, pull it up, take a look at it to see whether or not it's constitutional or not.
Will this new
Representative Lamar, if you'll allow me, there was an issue, I understand, with this amendment. It wasn't on the dashboard. There was a technical issue. It is there now. You should be able to see it.
Oh, okay.
Sorry, Representative Lamar.
Thank you. I'm trying to ask my questions and pull up the amendment that wasn't filed. But my question is in addition, will this appeals court, thank you, Mr. Speaker, only deal with issues coming out the legislature, or will they deal with other issues as well?
Chairman Farmer.
Yeah, thank you, Madam Chair. And this court could deal with a host of issues.
Okay.
Representative Lamar.
And I'm just going to wrap it up. And I've come to you beforehand, express my concerns, and I'm not trying to, I'm not coming at you. I'm just coming at the bill. I think this bill is particularly very, very dangerous in order to create a new court system. I think what we need to do is respect the judicial system as it is, the way it was made, respect the judges that we elect on our local level. And it creates the opportunity for partisanship because we are allowing our governor, who's a partisan election, to handpick 3 new judges that, again, could particularly align with his views, which can look at many of the cases in a potentially a partisan view. There are so many individuals from the legal community out of my county who are terrified and are concerned about this piece of legislation. I think we need to really think strategically about pushing this particular legislation because it can be very, very dangerous. And I think to create a new court to determine the constitutionality of these particular pieces of legislation is something that we should not be doing right now. We need to keep our judicial system in place, respect the judges that we already elect to office, and leave that as is. That's just my personal opinion on it. Thank you, Chair Lady.
Thank you. Speaker Sexton, you're recognized.
Thank you, Madam Chair. Chairman Farmer, aren't judges supposed to be fair and impartial?
Chairman Farmer.
Yes, Mr. Speaker, they are.
And does the governor not appoint appellate judges already?
Chairman Farmer.
You're correct.
Thank you.
Leader Lamberth.
Thank you, Madam Chairman. And to my friend from Shelby County, Davidson County does partisan elections for judges right now. So it is different than the Shelby County system that my understanding is nonpartisan. And so this will have a statewide voice in those judges that are hearing appellate issues specifically for this. And so that's a pretty big distinction. And I know, again, locally in Shelby County, they do nonpartisan elections, but in Davidson County and much throughout the rest of the state, that is not the case. But it is critical, and I know the sponsors already answered this question, that these folks be, nonpartisan in their rulings and that they be completely and totally without bias. And the more voices you have at the table, the better off that is. And so when you have retention elections, when you have confirmations, that puts a lot more checks and balances in the system, which is a much, much better way than it is now, where whoever has a lawsuit can basically cherry pick the most liberal judge they can possibly find in a partisan way and try to get a ruling at the trial level that the one you mentioned was overturned. And it took months for it to happen, but it was overturned. So, this is definitely a more fair way if you're in favor of truly unbiased judges that will be able to just make a determination in their expertise within a very small section of the law.
Representative Lamar.
Thank you, Chair Lady. Well, I would say that we need to maybe take a bite out of Shelby County's apple and leave our judicial system is. And if we can keep our judgeships nonpartisan like we do in Shelby County and elect them, let's do that. But I think this particular bill and what we're doing with this new statewide court system is unnecessary. Thank you.
Chairman Crawford.
Thank you, Madam Chair. Lady, move previous question.
The previous question has been called. Any objection to the question? Seeing none, we're voting on House Bill 1130. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. If you'd like to be recorded as a no, please see the clerk. Next on our agenda, House Bill 1132, also by Chairman Farmer. Chairman Farmer, you're recognized. We have a motion and a second.
It's from 4 companies: McKesson Corporation, Cardinal Health, Amerisource Bergen, or Johnson & Johnson, or their affiliates or subsidiaries. These monies would flow in this way. 15% would be directly to the municipalities. They can use it for anything they want to use it for, including attorney's fees to pay their lawyers. 15% would then go to the state money, and then 70% would go into the abatement council, in which 35% of that would then go back to the counties, directed back in, giving it a 40-60 split, 60 to the state, 40 to the cities and counties. And then the rest of that money will eventually end up in the locals' hands. Out of the abatement council, they'll just get requests from the locals, and the abatement council will take that into consideration, make sure it's for a good medical assessment treatment program or something, and then hand it down to the locals. So with that explanation, I'll renew my motion.
I'm sorry, we do have an amendment on this bill.
Sorry.
So if we have a motion on the amendment 7621, all in favor of the amendment, please signify by saying aye. Aye. Any opposed? The amendment is attached, and I believe that Chairman Farmer, you explained the bill as amended. Is that correct?
I did, Madam Chair, and I got the cart in front of the horse there, so.
That's all. It's
Apologize.
late in the session, and many horses and carts are switched
Right.
places at this point. I did have a question on the 15% that you said goes back to the locals for any use. Is that anything in their general fund, or is that anything related to the opioid issue?
Thank you, Madam Chair, for that question. As one member put it, I can't remember who it was. I believe they said that it could be used for anything, including planting flowers in a flower bed. So it's unrestricted monies.
Okay. All right. Are there other questions? Chairman Williams.
Thank you, Chairman Farmer. I appreciate your patience. This is something that's really important to me in my district because opioids have been a scourge there for over a decade. Matter of fact, the most of the bills that I carried early on when getting elected had to do with NAS, bursts, morphine equivalents, and the like. And so when we look at the broad spectrum of a multi-billion-dollar lawsuit and how it can impact the state, I think it's important that we understand and answer the questions so that we can go back to our districts and communicate what was going on. And I know I've asked you questions ad nauseum, and you've been fantastic about answering all of those. I just wanted to ask you about the 70-30 split of those monies that are distributed in the 70 by this abatement committee or this opioid committee. Can any of those funds be directed by that committee back to the folks that we settled this lawsuit with?
Chairman Farmer.
And thank you. And I know you had asked this question earlier in committee, and we'd had a discussion afterwards. And for the record, it's my understanding that, yes, that could be the case in a situation where that company's approved, say for Suboxone or something. They may manufacture that product, which is a product that's used to help folks get off the opioid addiction. So to answer your question, that could be the case if they had approved medical, like licensed treatment or some sort of product. So
thank you. I appreciate you always answering my questions, and I appreciate you trying to help me cipher through all this. I know that is a concern that I have, that we're taking the money that we win in a lawsuit and giving them their money back. I hope that when the abatement committee looks at this opioid task force or committee looks at this testimony, they'll recognize that majority of my district, the 42nd district, are not interested in giving the money back to the people that we sued. And so I appreciate you and your hard work here. I appreciate the AG and his hard work. I know it's been a difficult and long road, one that we'd like to get behind us sooner rather than later. But thank you, Madam Chairlady.
Chairman Farmer.
And I want to make one clarification. I tried to make a joke and it was a bad one. I know none of our locals would ever use this money in any other way other than to help folks overcome their addiction. It's a huge problem. It's a serious problem. So I want to apologize to the committee for that response I made. So,
Representative Ogles.
Thank you, Madam Chair. And to the sponsor, thank you for that comment. That was exactly my question. I'm a little concerned that we've taken some of the guardrails off some of that money and that we could actually use this for other things other than that it was intended through the settlement. So I certainly hope and want to put on the record that any money that's dispersed is used exactly for what it was intended to, and that's help those people that have been a victim of this crisis. Thank you, sponsor.
Leader Lamberth.
Thank you, Madam Chairman. And I want to echo Chairman Williams' comments. I hope that we could say that it's the legislative intent that these companies not be able to get money back, even if they provide a product. If we can get it anywhere else, that it would be our intent that none of these companies that we do business with them, if at all possible. I know we can't necessarily put that in the law. I know we can't do that. But Chairman Farmer, do you mind just kind of saying for the record that we would ask that this committee and that our communities try everything they can to do business with other folks? I mean, that we would not go down the road where any of these monies would go back to the very companies that we're settling with.
Sure.
Are there other questions?
Madam Chairman, I'm so sorry, but if he could answer that.
Oh, I'm sorry.
sure. And thank you, Leader Lamberth. And it's my understanding and interpretation that this is only dealing with 3 distributors and 1 manufacturer. So sure to goodness, we can find someone else to provide these products and services other than these 4.
Thank you, Madam Chairman, and thank you, Chairman, for saying that. And again, I applaud your hard work on this, just as Chairman Williams did. You've done yeoman's work on this. This has been a very difficult bill to try to handle with a lot of different parties. And you've done a fine job. Thank you.
Representative Shaw.
Thank you, Madam Chair. I just wanted to add, I think gardening is very therapeutic. I mean, even if they grew some flowers with it, I think it might be a great idea. Thank you.
Chairman Farmer.
No comment.
Again, I know, well, to echo the Leader Lambert's words, I know you've worked very hard on this. It's been a lot of negotiation, and I know that the overall goal for everyone is to make sure that the dollars that we're going to get from these settlements are used to address the issue and to help the people who have been harmed by the drugs that have been that we're now getting the settlement for. So we applaud you and your hard work, and a very complicated job it was, and thank you for doing that. Without objection, we're now voting on House Bill 1132. All in favor, please signify by saying aye. Aye. Any opposed? House Bill 1132 moves on to calendar and rules. Next on our calendar is House Bill 745 by Chairman Haston. We have a motion and a second. Chairman Haston, you're recognized.
Thank you, Madam Chair. This bill just offers the ACT Work Keys exam to all seniors in the state of Tennessee for the next 2 years. And with that, I'll be glad to answer any questions.
And I do believe we have an amendment we need to attach, Amendment 008086. We have a motion and a second on the amendment. All in favor, please signify by saying aye. Aye. Any opposed? None. The ayes have it. Drafting Code 8086 is attached. And Chairman Haston, if you could tell us what the amendment does, and I think you've explained the bill in general terms, but if you could tell us as amended.
Be glad to. The amendment just simply took it where the funds were subject to available funding to subject to available federal funding. And that got the fiscal note in a good posture. That's what the amendment does.
You've heard the sponsor's explanation of the amendment and the bill. Are there questions on the amendment or the bill? Seeing none, we are voting on House Bill 745 as amended, moving on to calendar and rules. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 745 moves on, and thank you, Chairman Haston, for bringing that bill. I know from my experience in my area that work keys are they're key, pardon the pun, or redundancy. They are really key to employers when it's something that they really look to determine if a potential employee is qualified to do the work. So thank you so much.
Thank you, Committee.
The next item on our agenda is item number 21, House Bill 1398 by Chairman Helton. Chairman Helton, you have a motion and a second, and you are recognized.
Thank you, Madam Chairman and committee. I do have an amendment.
We have a motion and a second. The amendment I'm showing is 8088. Is that the amendment that you have, Chairman Helton?
That's correct. Due to some concerns from TennCare and the state employee plan, the amendment clarifies that PBMs do not need to change the payment methodology for reimbursements to pharmacies, but outlines an appeals process for pharmacies if paid below actual cost. It also clarifies the acceptable format for data to be provided should the requesting entity earn a standard that is accredited by the American National Standards Institute, a common standard in the industry today.
You've heard the explanation of the amendment. Are there any questions of the sponsor on the amendment? If not, we're voting on Amendment 8088. All in favor, please signify by saying aye. Aye. Any opposed? 8088 passes and is attached to the bill. We're now looking at House Bill 1398 as amended, and we do have requests to go out of session for testimony. Are there any objections? Seeing none, we're out of session, and we would ask Michael Power and Trey Moore if they could come, whomever is speaking in opposition to the bill, if they could come to the table and give us your name and your title, please, and then we'll have testimony on the pro side following. And you have 10 minutes.
All right. Thank you, Madam Chair.
My name is Michael Power. I'm with the Pharmaceutical Care Management Association. We appreciate the opportunity to be here today to speak to this very important topic. Right now, though, we are respectfully opposed to House Bill 1398 as written. And we did take a look at the substitute language this morning real quickly. We're further reviewing that right now. But while we do think there are some improvements to the bill, we're still trying to get through all the changes that were there in those amendments. So again, the Pharmaceutical Care Management Association represents PBMs, so companies like CVS Health, Express Scripts, Caremark, and others. We operate across the nation. We have 66 PBMs that operate here in this country. They serve at the benefit of their clients, which are the employers here in the state of Tennessee and across this country. And we work with our clients to design benefit plans that help them provide healthcare coverage, including their pharmacy benefit to their employees, that not only is cost effective to the business, but also provides a service to their employees that they can afford and use here in the state of Tennessee. Real quickly, I'll get just sort of into the bill. As it's written, Section 1, we have not provided any comments on Section 1. We haven't had any issues with that section of the bill. Section 2, dealing with any willing pharmacy language. Currently in Tennessee, you do have any willing pharmacy language on the books. This language here does change what is in existing law. We feel like it is trying to go after the ERISA plans. One thing that I would like to point out is that it was raised earlier about any willing, or about the mail order pharmacy piece. We have a different opinion on how this bill is written and what this language does. And the way the language is written in Section 2 is it would eliminate exclusive mail. So a client may choose mail. So a business here in the state may choose mail to provide the prescription benefit on certain drugs to their employees. The choice there is these drugs are readily available to be shipped via mail. It's safe to be shipped via mail, and it is effective. And so the business is making that decision to not only save money for them in their plan design, but also to provide drugs to their employees in an appropriate time and in a cost-effective manner. When you have exclusive mail opportunities, there are discounts that do come with those. And so it does help make the cost of those drugs more affordable to the beneficiaries here in the state of Tennessee. Moving into, steering. There was some issues with steering in Section 2. Again, the way the way things work today is a client does get greater discounts when they do send market share to a pharmacy here in the state. And so the greater volume that they can drive, the better discounts they get, the more money they can save, and the more benefit they can provide to their employees who get their self-insured benefit from the employer. Section 3, the amendments there, have not had a full chance to digest those. We'll take a greater look at those. Section 4, we're not really sure what the legislative intent is there. There was an amendment earlier on in the process that removed a few words. And so we have some confusion with that section of the bill. Section 5, I think there was some language there that was a change in the amendment this morning. And again, we're taking a deeper dive at that. One thing I would like to say overall, there was a discussion this morning in the subcommittee about the Rutledge versus PCMA decision. What is important to know that the decision focused on Arkansas Act 900, which was a MAC reimbursement law. The law did not look at any elements of plan design, which we're discussing here today in House Bill 1398. And so what the decision focused on was that MAC pricing was something that the states, so pricing is like a tax, states have the right to review and impose those things on their citizens within their state. They looked at a 1995 traveler's decision and based all of their findings off of that 1995 decision. And so the decision did not look at plan design elements like any willing pharmacy, like mail, like spread pricing. All of those were not included in Arkansas Act 900, which was the focus of the Rutledge versus PCMA court decision. And so it is from our perspective and others that that court decision does not give states the authority to impact plans that are self-insured and are protected by ERISA. ERISA was established so that when businesses provided health insurance to their employees, if their employees are traveling across the country, they would be guaranteed the same level of benefit from their health plan in another state if they were to become injured or sick. And so ERISA was established to provide uniformity across the states so that when an employee was insured in Tennessee, if they were traveling to Georgia, Alabama, anywhere, and they were ill or sick, that they would be covered under their benefit that is provided voluntarily by their employer. So, with that, we respectfully disagree to the position earlier that Arkansas Act, the Rutledge PCMA decision, provided blanket authority to regulate self-insured plans. And the other thing that was noted in their decision by Justice Sotomayor, who was the justice who sat over the decision, was that the decision, or sorry, states that were regulating pricing could increase rates. So they could increase costs to the businesses in the community. And so they said, while states do have that authority, they have the authority to tax, it doesn't necessarily mean they should. And so that was part of the decision that was issued by Justice Sotomayor in that court decision. So with that, I'll conclude my comments. Happy to take any questions. Thank you.
Thank you. Are there questions? Representative Lamar.
Thank you, Chair Lady. So could you just explain in a little bit more detail the impact it will have on consumers? If this bill passes, like, will our health insurance go up? If it will go up, by how much? What does that cost really look like to us if this bill passes?
You're recognized.
Thank you, Madam Chair. So the cost can be pretty substantial. I think there was a letter put out that there's 3.5 million lives covered here in Tennessee by self-insured plans. The tools that those plans use, 3.5 million individuals covered by self-insured plans. The tools that we're talking about here in this legislation do help drive down costs, depending on which provisions you look at. Any willing pharmacy spread pricing that could have a dramatic increase in costs. Millions, hundreds of millions of dollars annually in the prescription drug space that ultimately will be passed on to the consumers.
Thank you, Madam Chair. Can you tell me everything that the PBM does in the prescription marketplace?
Everything? Oh, sorry.
I mean, do they set formulary? Is that accurate?
Mr. Power.
Thank you, Madam Chair. They do work with the Pharmacy and Therapeutic Committee, which is staffed by clinical and medical experts to decide what drugs are on the formulary. Yes, sir.
So they set their own formulary?
They work with third-party experts, sir.
So Express Scripts does not set their formulary via Express Scripts?
Mr. Power.
Sorry. Thank you, Madam Chair. They do work with the Pharmacy and Therapeutic Committees to establish the formularies, and the client ultimately has a say in which drugs are included on their formulary if they disagree.
So the PBM sets formularies. All right. So the second thing is, does PBMs do any patient steering?
Mr. Power.
Thank you, Madam Chair. So if a client would like to use mail, exclusive mail, then they would go out and negotiate the best deal for that client. And if it did include exclusive use of a specialty pharmacy for that client's benefit, then the client would sign off on that. And yes, they would use steering.
So does PBMs own specialty pharmacies?
Some PBMs do. The majority of PBMs do not.
3 PBMs make up 80% of the marketplace. Is that accurate?
Mr. Power.
Thank you, Madam Chair. Yes, sir, that is true.
So how many PBMs did you say were out there in your testimony?
Mr. Power.
Thank you, Madam Chair. There are 66 PBMs that operate across the country.
And 3 of them have 80% of the market share.
Mr. Power.
Yes, Madam Chair. Thank you, Madam Chair. Yes, sir, they do.
And the PBMs also, some insurance companies own PBMs.
Mr. Power.
Madam Chair, yes, sir, they do.
Some PBMs own their own pharmacies.
Mr. Power.
Madam Chair, yes, sir, they do.
And PBMs also own their own specialty pharmacies.
Mr. Power.
Madam Chair, yes, some do own.
Is that called vertical integration?
Mr. Power.
Madam Chair, thank you for that question, sir. There's vertical integration in manufacturing supply chains and a lot of supply chains that I think that would be more appropriate. I mean, sure. Yes, I mean, it is vertical integration, but there are monopoly rules that are governed in the federal government. And if we were violating monopoly rules, we would be being looked at.
And do PBMs do spread pricing?
Mr. Power.
Madam Chair, if the client would like us to use spread pricing, it is a plan design tool that the client can choose.
Can you tell us what spread pricing is?
Mr. Power.
Madam Chair, yes. So one of the most simple ways to think about spread pricing is if you're a consultant, you either get paid a fixed rate hourly or monthly, or do you get paid an hourly rate? And the way spread pricing works is a client has the right to choose whether they pick a fixed rate for their benefit. And what that does is that it helps eliminate risk to that client. So if there is a need for very expensive medications, they've established a flat rate that they're going to pay through the PBM and be reimbursed. And then if there's lower drugs, they're still going to pay that same rate. So there are instances where there are generic drugs that are dispensed under this plan, the PBM would pay at a higher rate than the drug is actually costs. And then there are some examples where you may dispense a drug at a lower reimbursement because of that spread pricing plan that the client chose to elect.
Right. Spread pricing is where you charge more to the health plan than you reimburse to the pharmacy. And so there's an example, because I called some of my local pharmacists, and here's just one example. You have a Symbicort inhaler, which is a brand name, which is $355.86. The generic is $240.10. The patient's copay on a brand name is $25. The copay was $10. The PBM did not offer the generic, only the branded. So in your example, the business has to pay $115 more because the generic was not on the formulary. Also, the patient had to pay more because the generic was on the formulary. Thus, they had to pay $15 more out of pocket because the copay for brand is higher than copay. And guess how much the pharmacy got reimbursed for that drug that was $355? $308.38 is what that pharmacist got reimbursed. And so I appreciate you sitting here and telling us that businesses are saving money. I'm not quite sure about that, but what I do know is the PBMs are now, 2 are in the top Fortune 500 companies and 3 are in the top 15. That wasn't the case 10 years ago. So I'll just leave it at that. And then there's also something that's not in this bill, DIR fee. And what happened, guess what? 2 months later, they went back and took another $6.95 away from the pharmacy. The pharmacy filled a prescription to help somebody, and they lost $40 below what they actually cost them. And what this bill does is doesn't allow for that to happen. It just says all pharmacies are created equal, and that you can't reimburse PBM-owned pharmacies at a higher rate than the independent pharmacists that we have in our communities. And so when we look at this, the issue that we're having is the PBMs, in my opinion, and we didn't even get into the rebates, because you do get rebates from drug companies that you keep as profit. And so the last thing I'll say, Madam Speaker, is if you want to talk about drug costs, if a drug costs X, if a pharmaceutical sells a drug or offers it to PBM to get its X cost, to get on their formulary, they have to rebate it. They have to rebate it, right? So they have to pay them a fee to get on their exclusive formulary. And guess what happens to the cost of that drug? The cost of that drug goes up. It goes up. And if this system was working, you wouldn't see the PBMs being Fortune 500 companies. You wouldn't see PBMs owning, as he just said, pharmacies, special pharmacies. You wouldn't see insurance companies owning PBMs. And I agree with you. I think this is a monopoly because you own all sectors of the healthcare market. And so with that, thank you, Madam Chair.
Are there other questions of our,
Madam Chair.
Mr. Power? Sorry, you're recognized.
If I could, I just would like to I did not say that PBMs were monopolies. I just wanted to sort of clarify that. And I do want to just state that when we talk about rebates are used either the client chooses for the rebate to go back to the consumer or their beneficiary, or they use the rebate to lower the monthly premium. So rebates do go back. I do want to remind everyone that drug manufacturers do set the cost or set the price, and they do that with federal patent law. So really, when we talk about brand drugs, sometimes there's only one drug on the market. When we talk about diabetes medication, there's 3, and that's because they have federal protection under trade secret, or they have federal patent law protection. So, and we do have a drug pricing problem, and we hear you, Mr. Speaker, and we are trying to be part of that solution. Thank you.
Are there other questions? Oh. We are out of session, Chairman Crawford, but I appreciate your sentiment. If there are no further questions for Mr. Power, we'll excuse you and we'll ask our subject matter expert on the other side of this issue to come forward. And some of you may recognize him from those people we sometimes see across the way. Senator Hale. Senator Hale, you're recognized.
There we go. Okay. Thank you, Madam Chairman and members. I appreciate the opportunity of being here today and to be asked to present. As you know, or I hope you know, I serve as state senator from District 18, Sumner County, Trousdale County, and a portion of Davison County. I'm a pharmacist by trade, independent pharmacy owner for 40 years. I sold my pharmacy about 10 years ago before coming down here. My license has lapsed, so I'm no longer a current practicing pharmacist. I served on a buying group. We served as a PSAO, we served about 1,500 stores in 22 states. I did that for 10 or 15 years. I want to share with you 3 examples that have taken place in my practice historically. In doing this is a really complicated issue. That's the reason that we've not been able to move forward in some PBM reform before now. It's really complicated. And so I want to give a little bit of education concerning NDC numbers and some billing processes. Prilosec 40 milligram, made by AstraZeneca. The first 5 numbers are the company. The next 4 is the drug, particular drug. The last 2 numbers is a package, not necessarily the same number like the quantity 30 is listed as number 31 with AstraZeneca. There are repackers. They buy in barrels of 50, 100,000, repackage that. They use their own NDC number. And then there's lots of companies that do this. As an example, I've pulled up on this product, this is generic Prilosec 20 milligram. There were probably 40 to 50 items listed on that. I want you to notice on this, the AWP, average wholesale price of these drugs. They're listed there. It goes from 6 cents a capsule up to $8.90. A lot of in between there, a lot of variation. And so I want to tell you a story that took place. And we stumbled upon this when I was serving on the board of this regional buying group, grocery store chain out in Arkansas. They were the... So as we look at this, AstraZeneca with a quantity of 30 had a drug cost, AWP of $100. Repacker, we're not sure what that price would be. And the mail order house had a quantity of 30. So here's the story at $300. Here's the story. And we figured this out through this Arkansas situation that came up. I had a customer come into my store, bring in a bottle from a mail order. It was repackaged, had NDC number on it, different than what I purchased and dispensed. So in looking at that, I started trying to figure out what this was about. How did they pay? What was the billing? The prices you see up there, the $100 on AstraZeneca is about what I was paying for a bottle of 30. The NDC number on the bottle that the lady brought into me was approximately $300. I want you to remember the cost, net cost is about $85 on both of these products. I took that NDC number on that mail order bottle that the lady brought to me. I ran that NDC number, which according to my contract is fraud. I backed it out, but I ran to see what they would pay. On the AstraZeneca NDC number, I got the $100. On the mail order bottle and using that NDC number, I got about $325 that they would have sent a check to me for. Think about that as we continue on. So you have a contract with lumber company ABC, and they say, all right, if you use independent pharmacy company ABC, we'll give you a 10% discount off the AWP. But if you'll use our mail order or one of our pharmacies, we'll give you 30% off of AWP. And so the question I ask, which AWP? And lumber company ABC should be asking that question. I'm not sure they have. So the next slide I want to bring up, situation. I dispensed insulin to a patient, insulin. It was written for 6 bottles, which was a 90-day supply. My tech, by mistake, ran it through as a 30-day supply. I want you to remember, this is not a drug that is abused or sold on the black market. It's used by the patient. 6 months later, she comes back, not 6 months, 3 months later, 90 days later, she comes back. We refill the prescription. Now, I want you to remember, my responsibility as pharmacist is check it's the right patient, right physician, right dose, right drug, on down the line. My responsibility is not to see whether we got that 30 days in or right when it comes across as a final check. My tech's doing that for me. Well, she made a mistake, an honest mistake. After we fill the second prescription, I get audited. They come in the store and audit. Well, what would you think would be fair? To go back and say, well, you should have collected that $20 copay 6 times rather than 2. And your dispensing fee should have been $10 times 6 rather than $10 times 2. The cost of the prescription, $1,000. They took it all. They took every bit of it with no recourse. Am I angry? 15 years later? Yes. If you couldn't tell. Specialty pharmacy. I also had a specialty pharmacy at one time. Specialty pharmacies do admix mixtures. They put ingredients together. They also identify those products, mark their price on them, and dispense them to a patient. We were selling product for less, providing as good a service, and couldn't get referrals. I don't know why, but we couldn't get referrals. And we're doing the same thing at a lower cost. Finally, Speaker Sexton touched on this. These items on the left-hand side, the PBM controls contracting, which also has to do with formulary, Mr. Speaker. They control mail order. Let me stop in the middle of this. Not all PBMs have all this integration. Some do. They have retail, they have distribution, they have specialty pharmacies, they have repacking plants, they have some manufacturing, insurance you've already heard about, claims processing, they control the data, provider services. Drug Channels by Adam Thien at Pembroke Consulting. There's a link you can go to and read the article on it. Madam Chairman, thank you for your time. I appreciate being invited to speak.
Thank you for being here. Are there questions for Senator Hale? Leader Lambert.
Thank you, Madam Chairman. And Senator, obviously, everybody here has a deep level of respect for you, and I voted for you several times, and you're my friend and my senator. So I want to thank you for coming over to the House and testifying. And, if there are many reasons to support this bill, but I trust your evaluation of these issues explicitly because for decades you've lived this. And the only question I really have is if we pass this bill, will it at least help eliminate some of these issues?
Mr. Leader, I believe that it will. I believe that we have to make some effort toward this. There needs to be some controls put in place. And then, and to ABC Lumber Company that I referenced, I strongly recommend that they begin some real deep dives into this information that is not available.
Thank you, Senator. Appreciate your service to our state. Appreciate your testimony today. And thank you for your guidance in this important legislation.
Representative Sparks, you're recognized.
Thank you, Senator. It's a big issue. Back home, I've had independent pharmacies. Pharmacists asked me about this. You probably remember my late stepfather, Dr. William Chance, that was a state investigator for 25 years up here. He's now deceased. It is a monopoly, but one thing I want to point out to the speakers here, I don't see anybody from the media here to even cover an important issue like this. It's not controversial enough. You know what, Senator? Have we ever had a task force study to dig deep into this? Or any other task force that we could dig deep into it?
Not that I'm aware of. I came down when I was practicing pharmacy and testified before either the House or Senate. I don't remember back then concerning this issue, but it's extremely complicated.
It is complicated, yes.
It is extremely complicated. And even when I was practicing pharmacy and I was on this buying group committee that covered 22 states, and we were going in all kinds of states trying to figure this out. It was extremely difficult and confusing. And what you found out today changed the next day.
Yes, sir. Thank you, sir.
Speaker Sexton, you're recognized.
Thank you, Madam Chair. Senator, thank you all for being here. Just two quick questions. Will this help pharmacies and patients in Tennessee?
Absolutely. I can tell you that I have been contacted by pharmacist owners that said that if this doesn't pass, they're selling. My store was in business for 125 years, and it sold last year. The new owner said it was because of this. I want to be completely honest. There are other issues there also that came into play, but this was a big one.
And then my second question, the lumber company that you mentioned, do you feel like that, one, they have control over their formulary as the previous person spoke? And two, do you think this will actually, once this passes, help them control costs or save money, or is what some people have said is increase their costs?
No, I think it helps them. I think it helps the patient. I think it helps the company. I think that they're going to have to do it's going to be dependent on them to really ask them hard questions and get some real deep answers on what they do. I did speak when Representative Shepherd was down here, a good friend of mine, and we were talking about this issue a number of years ago, in particular about the TennCare formulary, and about if the PBM wasn't there, what could the state do? And my question to him, because he had served on the TennCare formulary for years, those of you that were down here and remember that. And he said, absolutely, the state can do everything the PBM is doing as far as the pricing for TennCare.
Thank you, Representative Garrett.
Thank you, Madam Chair, and Senator, thank you very much for being here. Remind me to not make you angry ever again, but I do appreciate being your constituent. I do appreciate you being here and testifying in our committee. One thing that I do find interesting listening to the speaker before you and then listening to you is that within a few minutes of your comments, you actually mentioned the patient. And let it all be known that we are here for a patient-driven healthcare industry, which we don't have today. And so I appreciate you being here and mentioning the actual word patient. And for all purposes, I never heard of the word PBMs before I got down here, and I hope that I don't have to. So I appreciate you being here and testifying, as we need to have a patient-directed healthcare system that we actually think about the patients before we think about our profits. So I appreciate you being here. Senator, thank you.
Representative Shaw.
Thank you, Madam Chair. David Shepard was my classmate, Senator. But I remember, and Leader just reminded me of this, even in our National Black Caucus, this had been talked about some. Is it true that because of what we're talking about today, it has driven pharmacists out of low-income communities?
It has driven pharmacists out of business. And in the big picture of that, yes.
Well, I
Only
think,
low income, I couldn't say that, but yes.
Representative Shaw.
thank you, Madam Speaker. I thank you for your testimony, and I thank Speaker Sexton, because I think this is critical, and I think it's something that we need to rise above our partisanship and race and all of those other issues to work on, because that's very important to us and to all of our constituency. So thank you very much for that.
Thank you.
Senator Hale, I have no further questions. Thank you for joining us. And thank you, Mr. Power, for being a part of the testimony. Without objection, we are going back into session. And we are now back on House Bill 1398 as amended. Chairman Helton, you're recognized, and
Thank you. Thank you, Chairman Hazelwood. I want to thank Speaker Sexton and Senator Hale for covering all my talking points. I would like to recognize some of the organizations that are in favor of the bill: the Tennessee Oncology Practice Society, Tennessee Primary Care Association, Tennessee Medical Association, Tennessee Public and Teaching Hospitals, SIMPA Community Care, Tennessee Pharmacists Association, EPIC, which is the Electronic Privacy Information Center, McKesson, Life Sciences of Tennessee, National Infusion Centers Association, American Diabetes Association. And I would like just to read a letter from a small pharmacy in Hamilton County that I received this morning. Good morning, Ms. Helton. Here is our story in a nutshell. For many years, we had a great relationship with the largest employer in our area. The PBM servicing their account performed a very aggressive, overreaching audit of our store and created a narrative that this employer should remove our pharmacy from the network. Even after 3 other audits that were exemplary, a state board investigation that was immediately dropped in our favor, multiple attempts to reconcile, the employer and PBM continue to say, we are an ERISA plan and therefore do not have to abide by state PBM any willing provider laws. The result was our pharmacy losing 35 to 40% of our business and a 50% reduction in staff. Furthermore, we still have to this day, employees of that company requesting our services, many of whom continue to utilize our pharmacy and bypass their company-provided benefits in order to utilize us as a provider. Thank you for your efforts in supporting small business and independent pharmacies. Sincerely, Greg Bohannon. And with that, Madam Chair, I'll renew my motion.
Right. Thank you, Chairman Helton. Chairman Zachary, you're recognized.
Thank you, Madam Chair. Members, just a comment. I spent the last 2 terms on the Insurance Committee, and I would sit in this room in particular, and I would hear over and over and over again, it's about the patient. It's all about the patient. Well, I think just based on the brief testimony and the explanations we've heard related to this bill, related to the PBMs, it ain't about the patient. It is about profit. You look at that board right there, and I'm so glad that slide was left up. How does the consumer win when one entity controls every aspect of the pricing and the distribution? And then the final point, I would say, I worked with Senator Hale. I don't think he's still in here. I worked with him with this ad hoc committee, and I think he is about as steady as anybody I've worked with. And when an issue gets under his skin and creates that kind of emotion with him, I think we all need to address it. This is well overdue. When prices and the impact to the consumer continue to rise, when corporate profits continue to rise in relation to that, and then we continue to hear it's about the patient, something's wrong with that. So, Madam Chair, I would just say the importance of state government is magnified with a bill like this, just based on the comments I heard from Representative Shaw and others. Washington can't seem to agree on anything, but when it's an issue that impacts the people we represent in such a negative way, we in Tennessee come together here in the legislature. So I appreciate that, especially with my colleagues on the other side of the aisle. This is long overdue, and I appreciate the bill. Thank you for bringing it.
Are there other questions? The question has been called. Any objection to calling the question? Seeing none, we're voting on House Bill 1398. All in favor, please signify by saying aye. Aye. Any opposed? House Bill 1398, as amended, moves on to calendar and rules. Thank you,
Thank you.
Chairman Helton. Chairman Helton, you also have House Bill 330, which is the next item on the calendar, item number 22. You're recognized on that bill. We have a
Thank you.
motion and a second.
Thank you, Madam Chair. This bill seeks to extend the payback period from 30 to 35 years, during which a certain portion of state sales taxes are allocated and distributed to a municipality or industrial development corporation that finances the development of an extraordinary retail or tourism facility project under the Act.
You've heard the sponsor's explanation. Are there questions? Seeing none, we're voting on House Bill 330. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 330 moves to calendar and rules.
Thank you, Madam Chair
Chairman
and members.
Helton. We're going to back up now and go to item 8 on your calendar. That's House Bill 419 by Chairman Sapicki. Chairman Sapicki, you're recognized.
Thank you, Madam Chairman. House Bill 419, basically what it does is adds chiropractic care as an option for TennCare patients over the age of 18. It is now there for patients under the age of 18. This will now allow for people over the age of 18, Madam Chairman.
Thank you for the explanation. Any questions? Question has been called on the bill. Without objection, we're voting on House Bill 419. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 419 moves on to calendar and rules. Chairman Sapicki, you also have the next item on our calendar. That is item number 9, House Bill 6. You're recognized.
Thank you, Madam.
We have a motion. We have a motion and a second. Thank you, Chairman Sapicki.
We do have an amendment on that.
The drafting code I'm showing on that is 008070. Is that what you have?
That is correct. Yes, ma'am.
We will, without objection, we're voting on amendment 008070. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and the amendment is attached. Chairman Sapicki, if you would like to explain the bill as amended.
Thank you, Madam Chairman. First of all, thank you for the opportunity to come back here. I was out defending the honor of Tennessee, and that's why I was late. I do apologize for that. Also, what this bill does is we have a graduation rate problem with Tennessee Promise. It has now dropped to 51%. What this bill, and in that, one of the main problems with that are the kids, the students out there who have life that comes up and bites them and otherwise knocks them out of their graduation. What this does is create a completion grant for those that can get them across the finish line. We hope to raise our graduation rate from Tennessee Promise to 51% up to the mid-70s, which would put us #1 in the country. With that, I'll be happy to answer questions.
Are there questions for the sponsor? Question has been called. Without objection, we're now voting on House Bill number 6 as amended. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 6, which I think is a great bill and will help students in my area and across the state. So thank you, Chairman Sapicki.
Thank you, Madam
move
Chairman
on to
Committee.
calendar and rules.
Thank you.
That brings us back to item number 23 on our calendar, and that's House Bill 1433 by Chairman Holtzclaw. Also, Leader Lambert. Leader Lambert, can you, would you like to present the bill for us?
Second.
We have a motion and a second.
I'll stand ready for questions.
1433.
Madam Chairman, the bill creates a C felony for discharge of a firearm from motor vehicle.
You've heard the explanation. Are there any questions? Seeing none, we're voting on House Bill 1433. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 1433 moves on to calendar and rules.
Thank you, Madam Chairman.
Next on our agenda, we have, we're moving on to the Chairman Littleton agenda. Is Chairman Littleton with us?
Motion on the bill.
We have a motion and a second on House Bill 417. Chairman Littleton, you're recognized.
Thank you, Lady Chairman. This bill adds to the definition of severe child abuse the act of knowingly allowing a child to be within a structure where a Schedule II controlled substance, cocaine, methamphetamine, or fentanyl is present and accessible to the child. Just a few months ago, there was a 4-year-old that got a hold of his dad's heroin, and they were rushing him to the hospital, and they had some Narcan in the car with them, but they ended up giving him 2 sets of Narcan, and that's all that saved the child's life. So now children are ingesting their parents' drugs. So this would remove the child from those homes.
All right, you've heard the sponsor's explanation and the tragic circumstances that brought this bill to us. Are there any questions? Question has been called. We're voting on House Bill 417. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 417 moves on to calendar and rules. The next item is House Bill 427 by Chairman Littleton. We have a motion and a second. Chairman Littleton, you're recognized.
Thank you, Lady Chair and committee. This bill revises the parties with which a victim of sexual battery is incapable of consenting to sexual contact with to a member of the clergy, a healthcare professional, or an alcohol and drug abuse counselor who was treating the victim for a mental, emotional, or physical condition.
Members, you've heard the sponsor's explanation. Are there questions? Seeing none, we're voting on House Bill 427. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 427 moves on to calendar and rules. And that brings us to the end of the Chairman Littleton calendar with House Bill 951. We have a motion and a second. Chairman Littleton, you're recognized.
Thank you, Lady Chairman and committee. This creates an A misdemeanor offense of negligently by the act of omission engaging in conduct that places a child in imminent danger of death, bodily injury, or physical or mental impairment, and creates a Class D felony offense of negligently by the act of omission engaging in the conduct that places a child that is 8 years of age or less in imminent danger of death, bodily harm, or physical or mental impairment.
Are there any questions of the sponsor after hearing the explanation? Chairman Williams, you're recognized.
Thank you, Chair Lady. Chairman Littleton, I just want to say every year I come up here, I'm amazed really at the legislation you bring to protect kids across the state. It's unfortunate that you find so many areas where there are exceptions to what the law should be. And I just think this is a good opportunity to thank you for what you're doing here on these last 3 bills. Thank you.
Oh, thank you.
After that accolade, I assume there are no objections to calling the question. So we'll be voting on House Bill 951. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 951 moves on to calendar and rules.
Thank you, Lady Chair and committee.
Next item on our agenda is number 32, House Bill 656 by Chairman Moon. Chairman Moon, you're recognized.
Thank you,
We have a
Madam
motion
Chairman.
and a
There is
second.
an amendment on the bill, 8093.
That's the amendment that we have before us. Would you like to attach the amendment and then discuss it as a
Yes,
whole?
Madam Chair.
We have a motion on the amendment. Without objection, we're voting on Amendment 8093. All in favor of the amendments, please signify by saying aye. Any opposed? The ayes have it. The amendment is attached. And Chairman Moon, if you could explain the bill as we just amended it.
Thank you, Madam Chair and members. This bill is brought to me by the Comptroller. The amendment makes it abundantly clear there's no fiscal note now. Removes Section 3 of the bill. It revises and puts a parity of the 2 programs, the county certified finance officers and the municipal certified finance officers. It makes 16 hours of continuing education common for both plans, and it removes outdated compliance dates of the original law. And most importantly, it allows a municipality, a small municipality, to use a CPA versus sending one through the Certified Finance Officers Program.
You've heard the sponsor's explanation. Some members might want to get with you to see how you remove those fiscal notes, but it's done, and therefore
You
without.
file an amendment and rewrite part of your bill.
So you've heard the method and the means. We are, without objection, voting on House Bill 656. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 656 moves on to calendar and rules.
Thank you, Madam Chairman.
Chairman Vaughn.
Motion on the bill.
We have a motion and a second. Chairman Vaughn, you're recognized.
Thank you, Madam Chairman. Bill 1039 seeks to replenish our state unemployment trust fund by tying the benefit period to the unemployment rate at the time. It would, under the current scenario, all of our folks who qualify for unemployment are guaranteed up to 26 weeks. This puts it on a variable scale depending upon the amount of unemployment that's in the system, or the rate of unemployment at the time they file their claim.
Thank you for the explanation. I'm showing that we have an amendment that we need to adopt. Amendment 6977, is that? Chairman Vaughn, is that?
I thought that we had got, yes, ma'am, we do.
All
I
right.
thought well, that's right. We hadn't been here yet. We didn't-
No.
That's right. My bad. I was
All
sitting
right.
here in thought I was in a lot more comfortable position than I actually was, Madam Chairman.
Well, since we're just at the beginning of the Vaughn calendar, we'll make this exception. We do need to vote on Amendment 6977 going on the bill. Without objection, we're voting on that amendment. All in favor, please signify by saying aye. Any opposed? The ayes have it. Amendment 6977 is adopted. And Chairman Vaughn, if there's anything left that you need to say about the bill as amended, please feel free.
No, ma'am, I'll stand for any questions.
Leader Lamberth, you're recognized.
Chairman, thank you for bringing a good bill, and we welcome you back to the committee. But as far as not being here before, some of us actually have been here, and in fact, here all day. So committee, well done in your work so far, but we welcome you back to where we've been all day.
Thank you.
Representative Freeman.
Thank you, Chairman. Quick question. So the number of weeks is tied to the unemployment rate. What unemployment rate? Is it state unemployment rate?
It is.
Chairman Vaughn.
Excuse me. Let me see precisely. It's the adjusted unemployment rate. I do know that. State average unemployment rate calculated on a biannual basis.
Representative Freeman.
Thank you. So is the average unemployment, is that the rate that's currently or regularly reported that we hear, where 6 or 5.8? Is that what that average unemployment rate is?
Chairman Vaughn.
It would be the seasonally adjusted average unemployment rate that's published by the Department of Labor.
Representative Freeman. Thank you. So I guess here would be my only concern, and I'm curious what you have to say about it. For example, in Williamson County right now, the unemployment rate is roughly 3. And if you go to the other end of the spectrum, Lake County is 9. So we've got a pretty big swing. And my fear is that if you're in a county that has a higher than the state unemployment rate, if you're above that average, I'm afraid this could incentivize folks to move, because they would be penalized for the state average, where theirs could be significantly higher by as much as double. And so am I overthinking that?
Chairman Bond.
Thank you, Madam Chairman. There's a number of points that you brought up there, and there is some concern about geographic ranges that we see in this. But to that point, one of the things that I think it's really incumbent upon us to remember is that I hope nobody's going to move just so they'll get a better unemployment benefit. You know, that what unemployment's meant to be is to be a bridge to another career or another job. I know that with the extended benefits cycle that we seem to be on these days, that it has become a lifestyle for some, and that's not its intended purpose. This bill will take effect December of 2023. That's over 2 years from now. I'm sure that we'll be discussing this as things happen in Washington with some of the programs that our president has proposed. I think that we'll see some maybe some adjustments, but we've got to get the Department of Labor moving down this track because of the software and the vendors and things that it's going to take to do this. But I would say that hopefully we'll figure out by the time we get there any adjustments geographic. There has been conversation we have had about that.
Representative Freeman.
Thank you. And yeah, just to clarify, my question wasn't that people would move to extend their unemployment benefits, that they would move where unemployment was significantly higher than the state average, because they wouldn't be able to extend if, 10% unemployment, that's a significant number compared to 3. So, but anyway, I appreciate the intent.
Representative Shaw.
Thank you, Madam Chair. To my good friend, I got a whole bunch of questions here that were written out, but I don't want to ask those. I just want to get directly to the point. And I'm going to use our area for an example. You know our area pretty well. And we also know that this pandemic hit us. Nobody expected it. We just didn't know what to do. All of the above. So what happens if another pandemic or the same hit us and we only have 12 weeks of unemployment? And when that's up, what are people going to do? That's really where I'm getting to. I mean, what are they going to do? No jobs. We have very few jobs in areas like I represent right now. So what will they do after 12 weeks? I mean, are they just going to starve to death? What are we going to do?
Chairman Bond.
Well, that actually strikes at the very heart of the matter, Representative Shaw. And you know I have the affinity for your district that I do. It's my home. I think it's incumbent for us to realize what the word trust fund means. You trust that it will be there. Prior to the pandemic, our trust fund was not as solvent as it should be, and we were dependent upon the CARES Act from the federal government to keep it solvent during the pandemic. As a matter of fact, it must be true if you read it in the Tennessean. On May 3rd, an article from Mr. Ebert tells us that overall the balance of Tennessee's unemployment trust fund would last just 12 weeks if we did not do something to reform it under the past pandemic, if we hadn't pumped it up with the federal money. So what we're attempting to do here is much the way Joseph told the Egyptians, in the times of plenty, let's put it in the storehouse. And so it'll be there, and it will be a fund you can trust during the downtimes. And I, for one, while I appreciate our friends in Washington, I hate to think that our fortunes are constantly tied to them, that we would be able to carry and take care of our own. And in that situation that you were just talking about with the pandemic, the benefit period would grow up to 20 weeks, which is only 6 weeks less than what we've got now. So that's the thought process behind it, is let's put money away in the storehouse while we've got it. And then that way it'll be there for those folks that need it whenever we do encounter extraordinary times again.
Representative Shaw.
And I get that. And it was said earlier, you're right, this has kind of become a way of life some people. I'm not denying any of that. That's been discussed, but we got such a surprise. I guess my point is, I know we need to put money there. We need to save money. We're doing a great job, like our chair and all of this committee have agreed to put more money in rainy day, and all that is important. I get that. That's very important. But because we were unprepared for this, I guess the thing that I worry about is being unprepared again. And where do we get the money from? Of course, we've been fortunate to get some CARES Act money and other things to get us over. But I guess my whole point is this seems like an odd time to try to save rather than just try to survive, if that makes sense, until we can get to a point where we can save again. Maybe that doesn't make any sense, but that's what I just don't quite understand about reducing it right now at this time. But thank you for your comments.
Chairman Vaughn.
And I would like to remind you, Representative Shaw, that this would take effect in January of 2024. So that's quite a ways down the road. So we hopefully the COVID situation will flush itself out of our system. We'll find ourselves in prosperous times, and then we can begin saving. Because a lot of folks don't realize this. I've been on unemployment. You know, it was there when I needed it. And so I don't view this as light work. I view it as something that's very important to all of us. And when we started this exercise, honestly, we didn't, and particularly me, I didn't approach it from a standpoint of how do we get our workforce back into business. I was looking at it from the mathematical side of how do we pump our trust fund back up? How do we change the equation to where there will be money there? And what has happened is we've seen a slower recovery primarily due to workforce issues. And so then when you start looking at workforce issues, then you start looking at waste, fraud, and abuse and those other things that come along with it. But that was not the impetus of this bill. The impetus of this bill was how do we restore people's trust in our unemployment trust fund?
Chairman Zachary.
Thank you, Madam Chair. Chairman, thank you for the bill. As you said with the Joseph analogy, if there is ever a time for Tennessee to address the challenges that we face in unemployment, it's now. We are one of 7 states that grew during 2020. We have 248,000 plus jobs and careers available at jobs4tn.gov. We have created an environment for our economy to thrive, for unemployment rate to drop dramatically. And we're increasing the benefit while also reducing the weeks because it has to be addressed on the state level. I have a restaurant owner in Knoxville, Calhoun's Copper Cellar, 27 restaurants. He needs 300 employees today. He is having to close down restaurants and cycle through those closures because he can't find enough people to work because of the state money being paid and the additional $300 being paid from the federal government that's rolling through September. I don't think people realize what a harm that is to the economy and what a detriment it is to employment and to employers. I've got a lawn care owner who lives in the neighborhood next to me. He's offering $25 an hour to cut grass. He's had that out since April 15th. He has not gotten one application because people can make more sitting at home versus working. And so now's the time to address that. We've created an environment here in Tennessee where there are so many career opportunities available. And so I appreciate you bringing the legislation because now's the time to do it.
Thank you, sir.
Representative Sexton.
I just wanted to say amen to that biblical reference. Thank you.
The question has been called, and I would add to Chairman Zachary, I have friends in Chattanooga who own several restaurants who are having the same issue. They really cannot get enough staffing to keep their doors open. So thank you again for the bill. We are voting on House Bill 1039. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1039 moves on to calendar and rules. Next on the Vaughn calendar, House Bill 226. We have a motion and a second. Chairman Vaughn, you're recognized.
Thank you, Madam Chairman. This bill adopts the federal clinical laboratory improvement amendments, which are part of one of the governor's executive orders, which was put into place because our laboratories were understaffed going into the pandemic. These standards, which are in place in many states around the country, have served us well through the pandemic. We've had you notice the difference between the turnaround times and laboratory analysis at the beginning of the pandemic versus where they are today. We attribute much of that to the adoption of these guidelines. These are the same guidelines that the state labs operate under, so we would ask that they be adopted permanently.
Thank you, Chairman Vaughn, for bringing this bill. Again, I think it's an opportunity. People have found gainful employment, and without this bill, they would no longer be employable at these labs. So thank you for bringing it. Are there questions for the sponsor? Then without objection, we're voting on House Bill 226. All in favor, please signify by saying aye. Aye. Any opposed? House Bill 226 moves on to calendar and rules. Thank you, Chairman Vaughn. And
Thank you.
next, we're on your House Bill 443. Of motion and second.
And Madam Chairman, we have some amendments traveling along with.
Yes, we do. We have two, I believe. The first one is Amendment 8111. We have a motion and a second. Would you like to explain the amendment, Chairman Williams, since it's your amendment?
Yes, thank you, Chair Lady members. This bill is the bill we discussed in Finance Sub earlier. It creates an expansion of the current residency program for GME, graduate medical education across the state to the tune of $4 million. Those $4 million will be distributed the same way as they currently are. And then there'll be a new subsection which creates a doctorate of osteopathy at LMU with one hospital in each Grand Division that would train new residency programs. With that, happy to answer any questions that the chairman or members might have.
All right, you've heard the explanation of amendment number one, which is Amendment 8111. Are there questions on the amendment? Seeing none, without objection, we're voting on Amendment 8111. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. Amendment 8111 is on the bill, and now the next amendment that I have in front of me is Amendment 8128, also by Chairman Williams.
Thank you, Chair
We
Lady.
have a
members.
motion and a second.
Motion.
We have a motion and a second.
Thank you, Chair Lady members. This section 1B4 just substitutes the words shall for, substitutes word similar process instead of same process.
You've heard the explanation. Chairman Hawk, you're recognized.
Thank you, Madam Chair. Would it be a proper request to put these two amendments into one, or is that possible under this legislation?
Our legal folks have advised us that it's best to keep them separate.
Thank you, Madam Chair.
Are there any other questions? Seeing none, we're voting on Amendment 8128. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. Amendment 8128 is attached to the bill. We're now back on the bill as amended, and Chairman Vaughn, you are recognized.
Thank you, Madam Chairman. This is a situation that I have been passionate about for a number of years now, and that's breaking the log jam for medical residencies or graduate medical education throughout the state. A lot of folks don't realize it, but we've been blessed with a number of med schools in our state, yet we've been a net exporter of doctors because we didn't have the residency slots for them to receive hospital training. CMS, who runs the residency and I'm giving you all the benefit of all my vast knowledge that I've picked up over the last 2 years. CMS from the feds runs residency programs in our state through hospitals. Those hospitals direct those doctors in training into the fields that they want them to be in. And sometimes what happens is you miss out on some of those general practitioners and pediatricians that are some of the lower earners, but are some of the most necessary services required for more rural parts of our state. So what this program that we conceived is let's let the med schools determine, the state-ran med schools determine what these people are going to be studying within these programs. And what this plan does is it establishes 15 residencies in Chattanooga, 15 residencies in Jackson, 15 residencies in Knoxville, 16 in Memphis, 15 in Nashville. All those are going to be run by UT Center for Health Sciences, and then 24 in the Tri-Cities area that's going to be run by ETSU. And then, as Chairman Williams touched on, the additional $1.5 million is going to be run through the LMU med school. So this is a new concept. It's a new program. It's one that we hope pays dividend. We're expecting, I believe, about 140 new doctors, and it has been proven that doctors spend more time in their state that they do their residencies in. So we hope this will build our medical workforce.
Chairman Williams.
Thank you. I will be brief. Thank you, Chairman Vaughn, for this. I do think the members should understand that even though this is about residency programs across the state, it's really a jobs bill. 84% of the people that do a residency in your community will stay there. And so wherever they do their residency, and particularly this is a really big problem, which is why the new portion of this bill, and in addition to what Chairman Vaughn's been working on, what'll happen is that when we do these, it'll allow for subspecialty groups and other groups that are so hard to find in rural Tennessee to be able to take jobs in these rural areas and keep doctors in the state. So appreciate the bill. It's a really important part. Thanks.
Thank you. And I'd just like to add, I've had a long time interest in this. I've had many conversations with Chairman Vaughn about this issue, and I'm glad that we're very close to the finish line. Leader Camper, I saw your hand.
Thank you, Madam Chair. Madam Chair, I just want to make sure for the record again that Meharry and Vanderbilt is not being cut out of this program with the amendment. Thank you, Madam Chair.
Chairman Vaughn.
They have their citizens or their students are able to apply for these residencies just like anyone else. They aren't managing this program, but their med school grads are certainly welcomed into this program.
Leader Camper.
Thank you, Madam Chairman. Mr. Chairman.
Are there further questions? Seeing none, we're voting on House Bill 443. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 443 moves on to calendar and rules.
Thank you for spending time with me today. It was delightful.
Next on our calendar is House Bill 1246 by the most patient man in the legislature. He has been here throughout this. Representative Calfee, you're recognized, and let the record note that he's missing his own party to be here in finance, because I think as we have been here, the toddler shower for his new member of his family, Mr. Sawyer, has been going on. So we thank you for choosing us over that, and apologize for your long wait. Representative Calfee, you're recognized.
That's okay. This is a bill I feel like should have been here a long time ago. It's a
You
student.
have a motion and a second. Go ahead, Representative
I
Calfee.
think Leader Camper stepped out during sub. I had misspoke during my first sub meeting that this is directed by the higher ed, not the Department of Education.
Thank you for that clarification. Are there questions? Question? Seeing none, without objection, we're voting on House Bill 1246. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it.
Thank you, Chair, Lady, and Committee.
Your patience was rewarded. You move on to calendar and rules. Next on our agenda is House Bill 22 by Representative Gillespie. Representative Gillespie, you're recognized. We have a motion and a second.
Thank you, Madam Chair and Committee. What this bill does is it increases the penalty for organized street racing or drag racing from a Class B misdemeanor to a Class A. It's a big problem right now where I live and across the state. I believe this bill will help save lives in Tennessee, and I appreciate any questions.
Question on the bill.
Question has been called. Are there any objections? Seeing none, we're voting on House Bill 22. All those in favor, please signify by saying aye. Any opposed? Let the record, let the clerk know if you'd like to be recorded as a no, but the ayes do have it, and House Bill 22 moves on to calendar and rules. Next, we come to House Bill 1044 it's being carried today by Chairman Todd. Chairman Todd, you have a motion and a second, and you're recognized.
Thank you, Madam Chair. This increases the number of commissioners to the Tennessee Public Utility Commission from 5 members to 7, and requires that the new commissioners, the 2 new commissioners only, are to have no experience in a regulated utility industry. And then it increases from 30 days to 90 days, the amount of time the General Assembly has in confirming commission members.
Heard the explanation. Are there questions? Seeing none, we're voting on House Bill 1044. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1044 moves on to calendar and rules. Representative Hurt with House Bill 713 is next on our agenda. You have a motion and a second. Representative Hurt, you're recognized.
Thank you, Madam Chair. House Bill 713 addresses BEP funding following students that, because of students' treatment plan from a qualified physician, are sent to an out-of-state facility. It allows the facility to receive BEP funding for educational services provided during behavioral treatment. These facilities' educational programs will be qualified by the Department of Education. It clarifies that only when all options in Tennessee are exhausted, then the BEP funds can follow the student.
You've heard the explanation. Are there questions? All right, members, we are voting. I'm sorry, Leader Camper.
Thank you, Madam Chair. Mr. Sponsor, this is for like hard to place people that need certain help, support that they can't find here. And this is like the only place that they could go pretty much, and it just happened to be out of state.
Representative Hurt, you're recognized.
Thank you. Yes, ma'am. This is for medical treatment, for behavioral treatment for various students who have hard placement and they can't find a facility in Tennessee to be placed. They go out of state after that.
Leader Camper.
Thank you, Madam Chair. Thank you, Mr. Sponsor.
Are there other questions? Seeing none, we're voting on House Bill 713. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 713 moves on to calendar and rules.
Thank you, Madam Chair.
Representative Hurt. Next item on our agenda is House Bill 9 by Representative Reedy. Representative Reedy, you have a motion and a second. You're recognized.
Thank you, Madam Chair and committee. And of course, I want to state again, thanks to Commerce Insurance, working for 6 years on this bill. And Chairman Whitson, he was right there with me as well as, and I need to mention a couple names because it was in government operations. Chairman Mike Bell, we worked on this, as well as Chairman Jeremy Faison, to get it finally this far to take care of this issue and clean up Tennessee code. Madam Chair.
You've heard the sponsor's explanation. Are there questions? Representative Sparks.
I just want to commend you for carrying this piece of legislation. It's kind of a rare moment. Can you tell us what you do for a living?
I raise cattle actually for a living.
Well, what else you do? I just think it's great that you're looking at helping others out there to get into business and deregulate an industry.
Well, it was a great
conviction.
idea, Chairman Sparks, but it become a bad law.
Yeah. Thank you so much
Thank
for what you do.
Right. Are there any other questions or comments? Seeing none, we're voting on House Bill 9. All in favor, please signify by saying aye. Any opposed? House Bill 9 moves on to calendar and rules.
Thank you.
The next item on our agenda is House Bill 761 by Representative Sparks. We have a motion and a second. Representative Sparks, you're recognized.
Yes, thank you, ma'am. This bill simply exempts sales taxes from gun safes and gun safety devices, and I want to thank my co-sponsors for their help and others.
All right, we need to, we have amendment
There's an amendment.
6058 that needs to be withdrawn without objection. 6058 is withdrawn. We have amendment 7751. We have a motion and a second. And Representative Sparks, you are recognized on the amendment.
Yes, the amendment makes the bill much better, and I want to thank those for wanting to add this amendment to it. Okay, thank you.
Since that was my amendment that we attached, thank you for recognizing how much better we made your bill, Representative Sparks. And for the record, that the amendment just simply makes this the sales tax holiday effective for 1 year on gun safety equipment. Leader Lamberth.
Thank you, Madam Chairman, and thank you for the amendment on that. And to Representative Sparks, thank you for carrying a bill that I carried a couple of years ago, was unsuccessful in getting across the finish line. And I'm so proud to see that you are able to do this, and hopefully everyone will support it. We're all very strongly in favor of the Second Amendment, but this bill will save lives, literally. I mean, as the Second Amendment allows folks to protect themselves, it is also a responsibility to do so safely and do so wisely. And a gun safe in a variety of different versions, both sometimes in a vehicle or a home, is simply a common sense product to have if you're going to possess a firearm. So thank you for carrying this. I actually hope this will be something that might turn into a recurring expense. I know this is just a one-time for the next year bill for right now, but Representative Sparks, thank you for your leadership on this. And seriously, thank you for carrying a bill that is just a very solid idea. Thank you.
Thank you.
Other questions? Seeing none, we're voting on House Bill 761. Oh, I'm sorry. We have to adopt, got ahead of myself. We need to adopt Drafting Code 7751. We have a motion and a second on that amendment. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. The amendment 7751 is attached. Now we're voting on House Bill 761 as amended. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 761 moves on to calendar and rules.
Thank you.
Next item is number 69 on our calendar, House Bill 513 by Leader Gant. Leader Gant, you're recognized.
Thank you, Madam Chair. The amendment, are we going to take up the amendment, or is it?
We have a amendment 8124. Is that what you're showing, Leader Gant?
That is correct. And what the amendment does is just simply names this piece of legislation Law and Order Act of 2021.
All right. You've heard the explanation of the amendment. We're voting on Amendment 8124 being added to the bill. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. The amendment is attached. We're now back on the bill as amended. And Leader Gant, we do have someone who's asked to testify. Would you like to go out of session, have their testimony first, or?
Sure. Well, I'll tell you, let me talk to the bill first, and then we can go out of session, if you don't
All
mind.
right, Leader Gant, you're recognized.
Thank you, Madam Chair. Members, what this piece of legislation does is it increases the penalty of incapacitating a highway or other passageway to a Class E felony and a mandatory fine of $3,000. Section 2 of this legislation creates criminal immunity from prosecution for any drivers who are exercising due caution and who unintentionally cause injury or death to a person illegally obstructing a roadway. Section 3 creates a Class A misdemeanor for a person who throws an object at another with the intent of harming the other person while participating in a riot, and a Class E felony for a person who throws an object at another and causes bodily injury while participating in a riot. Section 4 creates a Class A misdemeanor for a person while participating in a riot who intentionally intimidates or harasses an individual in a public place who is not participating in a riot. And Madam Chair, I know what you're interested in is the physical cost of this is $335,000 for incarceration, future cost. And also, Madam Chair, my colleague, Chairman Zachary, also wanted to make some opening remarks as well, if you would yield to him.
Certainly, Chairman Zachary.
Thank you, Madam Chair, and thank you, Leader Gant, for the legislation. Members, just specifically the part of this piece of legislation I know that has created the most interest is Section 2. And I think it's important to point out that Section 2 references Code 3917-307. In the second sentence of this, it makes it clear that that this applies to those who are already in violation of subsection A. And let me remind you that in law today, it is currently a misdemeanor, and that particular section states a person commits an offense who, without legal privilege, intentionally, knowing, recklessly obstructs a highway, street, sidewalk, railway, waterway, elevator, aisle, or hallway to which the public or a substantial portion of the public has access, or any other place used for passage of persons, vehicles, conveyance, whether the obstruction arises from the person's acts alone or from the person's acts and the acts of others. So what we're referencing here is something that is already illegal and is already a misdemeanor. And every word of the legislation is important. And Madam Chair and Mr. Leader, I'd also go to the first sentence in subsection 2, where it says a person operating a vehicle who is exercising due care. That is a legal term that refers to the effort made by an ordinarily prudent or reasonable party to avoid harm to another, taking the circumstances into account. It refers to the level of judgment, care, prudence, determination, and activity of that person who would reasonably be expected to do under particular circumstances. The standard is applied to a vast variety of contexts, whether the duty may be driving on the road or performing a background check. The precise definition is made by a case-by-case basis. We had a situation in West Knox County last weekend, a neighborhood, and I'm very familiar with this because it was a neighborhood I used to live in. There were a large group of protesters that went into that neighborhood, blocked the neighborhood, blocked people from leaving, circled the cul-de-sac that I used to live in, and blocked driveways. And I became aware of this because a friend of mine who is a federal agent reached out to me and he said, hey, I just had some people in this particular neighborhood, not knowing I lived there. He said, they asked me to come over and remedy the issue with these protesters. And he said, what do you think I should do? I said, no. I said, I don't think you should go. So while I can appreciate someone's right to peacefully assemble, as it says in the Constitution, the definitions of assemble and protest is in Daniel Webster's 1828 dictionary are very, very different. And those reference in particular the First Amendment and the words used in the First Amendment. So anyone has the right to peacefully assemble to redress grievances. You do not have a constitutional right to impede and stop people from progressing with their day-to-day lives. Right now, that is already against the law in Tennessee. So we are simply saying, if you do like what you did to a state senator last year when 30 people surrounded his car and put signs all over his car and began to shake his car, if you do like was done in my neighborhood, my former neighborhood, where you block and I have people texting my wife saying, can he do something? Because people won't let us leave our neighborhood and they're blocking their streets. If you were going to stand in the road and impede people and intimidate people, that is not peacefully assemble. That is a protest used to intimidate. You need to get your butt out of the street and let somebody drive by. Or if you don't do that, that person, if they are scared for their safety and they exercise due care, they have the right to proceed, and you do not have the right to stop them. And so, Leader, I appreciate you bringing this piece of legislation. It's needed because every time we pass a piece of legislation like this, people respond because it becomes law, and then there's consequences to breaking the law. So, Madam Chair, I appreciate you letting me speak. Leader, thank you for the legislation.
Leader Gant.
Thank you, Chairman Zachary. And I just want to make a few closing comments. The biggest thing here is if someone specifically targets a citizen that may be protesting, maybe going about their way of showing their belief about something they're protesting against, and somebody specifically targets that person with their vehicle, they're going to jail. This bill does not allow someone to get away with specifically targeting somebody and running them over. Period. You're going to jail. And it is not peaceful to hold someone against their will. Madam Chair, I'm sorry I've taken this longer than I told you I would, so I turn it back to you.
That's fine, Leader Gant. I think this bill is important, and we, it's obviously there's a lot of explanation that and issues that have been raised. Representative Shaw, you have a question.
Thank you, Madam Chair. And I can appreciate all that's been said because I know that's aggravating. And matter of fact, I've had things like that happen to me. So what right now, if this law passed, will I have? I mean, if I got my piece in a car and some people try to stop me and block me, what right do I have?
Leader Gant.
I'm not sure I understand the question.
I mean, if I am blocked by these people we're talking about, blocking me like Representative Zachary just said, what right do I have now? Can I do what I need to do to get them out of the way? I got to call the law or what? I'm asking.
Well, first and foremost, you didn't ask to be in that situation, did you? Okay. And in this legislation, it says that if you're in that situation, that you must use due care. You cannot target somebody and say, I'm going to run them over because they're in my way. But you do have the ability under this legislation to use due care. And
That is due care. What, help me with that term?
Leader Gant.
if you accidentally run over somebody's foot, leg, and God forbid you accidentally run over that person, not intentionally, this bill protects you in that situation.
Representative Shaw.
Thank you. No. And I get what you're saying, but I'm just trying to understand, if they don't move, if they stubborn and don't move, what right do I have now? Do I have to pick up the phone if I can and call the police, or can I use any kind of personal force to get out of that situation without having to call the police?
Okay, I've tried to do my best
Leader
to
Gant.
explain it, so I'm going to yield to Leader Lambert.
Leader Lambert, you're recognized.
Thank you. Again, in any circumstance like that, if you can either, wait, call the police, do whatever is necessary to try to make sure that both you're safe and those around you, that's the wisest course of action. The circumstance you're describing is where it sounds like somebody's threatening you or your person. And that's kind of a totally different situation that doesn't really involve this bill. And whether this bill were to pass or not, the circumstance you're describing is if somebody's threatening you is what it sounds like. That's a totally different paradigm. This is literally where it just says exercise due care. And if somebody unintentionally causes injury, which, as the sponsors try to say several times, if somebody intentionally or with gross recklessness, is endangering somebody else, they're going to still get charged. They're going to get in trouble. They may very well get, convicted of something. But everybody still needs to just be careful. Take it easy, do everything you can, whether you're a protester or someone that's in a vehicle, to not endanger lives. The main point of this is that folks should not be out on the road in a situation like this, but at the same time, folks that are in vehicles should exercise due care. It's going to vary based on the circumstance, but there's not a clear cut, hey, if this happens, then this occurs. And everybody, again, should respect each other's lives and try to keep things tamped down and toned down so that they're a peaceful protest and they're peaceful, just citizens of the community that can go about their lives. So there's a way to get your message across without ramping it up to the level that you're describing.
I just wanted, I've kind of had a situation like that to happen. I guess in the case that you're being threatened is what I'm saying. If you, would the law protect, if I could prove that I was being threatened and I had to use some type of force to get out of the situation, I guess I'm just asking, would the law protect me in a case like that?
Leader Lambert.
So you have a right to self-defense in this state, whether this bill passes or not. That's really separate from this bill. But yes, sir, you have a right to defend yourself if yourself or someone else is being threatened with bodily injury or death. But really, it's kind of a separate issue from this particular bill. It doesn't go into that arena. But nothing in this bill would affect your ability to be able to defend yourself under the current laws of the state of Tennessee. I have for years, though, cautioned folks that just because you have a right to self-defense does not mean you should be eager to exercise that right. It should be something that is very carefully considered and to make sure that others in the area would be safe. Again, it's just something that every single circumstance is different. But yes, sir, you have a right to self-defense.
Representative Garrett.
Thank you, Madam Chair. And just to kind of elaborate a little bit on what due care is. Due care simply just means that what an ordinary person would do in the same circumstances. So in the analysis of whether or not that was reasonable, they took due care. They would take whatever facts there that took place. They would another person in those similar facts do the same thing. That's where we get where the due care comes into play. So I just wanted to make that clarification.
Thank you, Representative Garrett. Chairman Faison.
Thank you, Madam Chair. And I wanted to remind the committee that years ago, Tennessee became a state, and it's separate from this bill, but it's been talked about as a stand your ground. And a stand your ground means that if you or someone you love or with is facing imminent danger or feel like you're being threatened, you have the right to defend yourself, even with deadly force. And so, the question's being asked here, obviously, you need to give all due care. But if there is no way of escape, you can't get out. You have not only the right, but you have the responsibility to protect yourself and those who are with you.
Thank you. Leader Camper, would you want to ask your question now or after the testimony? Okay. Without objection, we do have, as I mentioned, someone who had asked to testify. Without objection, we're going out of session, and we will ask Amber Sherman, who is no longer in the room. So we're back in session. Leader Camper, you're recognized.
Thank you, Madam Chair. Mr. Sponsor, in this bill, is this dealing with riots or peaceful protests? Because I heard some scenarios where we were talking about peaceful protesting, but I thought you were dealing with rioting, which I think is two separate things. So could you explain is what this bill is doing as a particular? Is it dealing with both?
Leader Gant.
I'm sorry, Madam Chair. I don't think I understand her question, and I
So-
can't hardly hear you, but.
Okay, thank you.
Leader Camper.
So in the example that I keep hearing, we're talking about people peacefully protesting. And if something should arise out of a peaceful protest. But the way you have explained the bill is dealing with people that are rioting. So I think rioting and peaceful protesting is two different things. So could you explain, is your bill dealing with what's happening during a riot situation, or does this apply to both rioting and peaceful protesting?
Leader Gant.
Yeah, thank you, Leader Camper. What this legislation is there a certain section you're referring to? I want to make sure I answer your question correctly.
Leader Camper.
In general, because the examples that I keep hearing are about people doing a peaceful protest. But you set the bill up as if it was dealing with people that were rioting. So I'm just trying to get clarity of what your intent is. Is it to deal with the rioting, or is it to deal with peaceful protesting and rioting? I'm not sure which section. I don't have the bill in front of me.
Leader Gant.
I can try to pull it up though.
Thank you. Well, it's obviously dealing with citizens that are violating the law to begin with. Otherwise, this legislation would not be being brought. It's not peaceful to hold someone, against their will. There is no constitutional right that gives someone the ability to hold others against their will. So I'm not quite sure which section of it this legislation you're referring to, but there's situations that, say someone turns a corner and they're headed to the grocery store or headed to go shopping, and all of a sudden they find themselves in the middle of a situation they didn't want to be in. Just like Representative Shaw was referring to, this is addressing those types of situations. And, if you get outside the realm of peaceful protesting, I'm not quite sure what you're actually referring to. That is it okay to violate the law? I'm trying to understand your question.
Leader Camper.
I'm saying if there's a peaceful protest where, you have somebody has pulled a permit, they're doing a peaceful protest, they have the right to be out protesting, and someone may accidentally hit somebody, or somebody may feel intimidated, but they're peacefully protesting. They're not rioting. They're just walking down the street or doing, holding a candle or doing whatever it is that they're doing that they're authorized to do. They have a permit, but someone else feels intimidated by that. How would this bill address that? They're just peacefully protesting.
Leader Gant.
Thank you, Chairman. If you're peacefully protesting, this piece of legislation does not pertain to you.
That's the point I'm getting to. Thank you.
Chairman Williams.
I might be a little bit more confused, but I thought maybe if I could ask the legal question, how does this relate to false imprisonment then? If I'm in the parking garage and somebody impugns my ability to leave under this statute, would you have the same protections? Or, you know, we have lots of very famous people in the state, and people, one man's protest might be another person's. I'm for the bill. I think it's a good idea, but I just don't know if we're going down a road here we need to clarify with false imprisonment.
Go out of session and hear from our legal counsel.
Joel Hayes, Office of Legal Services. Chairman Williams, this bill does not directly address false imprisonment, but I can hopefully clear up a couple of things here. So one, sections 1 and 2 of the bill deal with obstruction of passage, a person's passage for highways, sidewalks, aisles, access to elevators, things like that. If that person is doing so without legal privilege, that's where Leader Camper was asking about pulling a permit. A person that pulls a permit for a peaceful protest or something like that would have legal privilege, you know, generally. Now, section 3 of the bill is where Leader Gant, that's referring to the riots, specifically referred to riots and the throwing of objects. But with regard to your question of blocking someone in, trying to leave a parking garage or something along those lines, it would depend on one, is there a permit pulled? Does the person blocking that access, do they have a legal privilege to do so? You know, and are inadvertently blocking access to that garage. Otherwise, yes, then it potentially could be without legal privilege, someone that would be blocking access to a parking garage could be, you know, this would apply to them as under the obstruction portions of section 1 and section 2.
Chairman Williams.
Thank you. The reason why I asked this question is I carried for many years a paparazzi bill because we're trying to protect artists that come here to reside across the state. The argument of it just being a permitted or a legal use versus somebody being able to be in a right of way or on a public sidewalk, it's a thin line there. And that's why I was wondering if it needed to be clarified, because in one instance, you may have a permit to do that, but some people have a right to be in a right of way. And if you're leaving a parking garage into a right of way, I'm fearful that somebody would have to say, well, I've got a legal privilege here, even though it doesn't have anything to do with that. I hope that you could speak to that. I support the idea. I support as it relates to false imprisonment too. But I think by giving the example that Chairman Zachary gave earlier about people blocking the right of way, that could be argued because they're in a right of way that it's false imprisonment because they had the right legally to be in a right of way.
Mr. Hayes.
So the definition of obstruct in this circumstance is to render passage unreasonably inconvenient. So if someone happens to be in the way, and it's just a matter of waiting for them to move, you know, that may not be an obstruction. But if someone refuses to move, then we're getting into the fact that they were likely obstructing someone's egress.
Chairman Williams.
Last, and I'll drop it. I was in a vehicle with my colleagues. We left last year. We were trying to get out of the garage into a right of way. We videotaped it. They were standing in a right of way. It's my understanding that if they did not move willfully, that under this statute, you could use due care and scooch them out of the way.
Mr. Hayes. And we'll ask for a definition of scooch.
I believe it's a scoocha.
based on the facts that you described just now and the circumstances that you described, it is possible that Section 2, I believe it's Section 2 of the bill, would allow due care to be exercised. And
Are there other questions for legal? Representative Freeman.
So you said reasonably inconvenienced. Does that mean that you can, there's an alternate route, or is it time sensitive? I mean, I'm not sure I'm understanding what that inconvenience piece means.
Representative Freeman, the statute itself defines obstruct as to means to render impassable or to render passage unreasonably inconvenient or potentially injurious to persons or property.
Representative Freeman.
So does that mean that if there is an alternate route, that you don't have to take an alternate route and can escucha someone out of the way?
Mr. Hayes.
It would really depend on the facts and circumstances of the case. I mean,
Leader Gant.
Thank you, Madam Chair. Question for legal. Is it illegal to be in the road blocking in this manner?
Mr. Hayes.
Later, again, that comes down to without legal privilege, that particular clause. Again, if someone has pulled a permit so where they have the ability to assemble in the streets, perhaps for a march or something along those lines, then they would be absolutely authorized to be in the street in that circumstance.
Leader Gant.
If they have not pulled a permit and they are in the road blocking ingress and egress, is that illegal?
Mr. Hayes.
It depends on the circumstances. I mean, again, if they are crossing the road, again, it depends on the particular facts. If they are just standing, obstructing the road, then chances are that they would fall under this definition of obstruction.
Leader Gant.
Can you give us the definition of obstruction?
Mr. Hayes.
Obstruct means to render impassable or to render passage unreasonably inconvenient or potentially injurious to persons or property.
Thank you, Madam Chair.
Representative Shaw.
Madam Chair, I'll be very brief, but that was really my concern because Chairman Williams just spoke to it. I mean, I'm not against the bill, but if we're going to pass it, I think it needs to help the citizens who are being abused. It looked like to me all the bill is going to do is help the other side. I mean, how does it help us? Because if someone is going to block the road, if they block the street, they already know they're violating the law, but they don't plan to let you out either. That's pretty much the bottom line. So and I hear about the due care and all, but if they really mean not to let you out and you're blocked in, you just need some understanding of a recourse.
Mr. Hayes.
Representative Shaw, I'm not sure. What are you asking me? I'm sorry.
I guess it's already been answered, but I guess legal has already been answered, but I'm for the legislation, not against the legislation. It's just that if I'm blocked in, if someone is protesting, whatever they're doing, and they block me in, they don't mean to let me out. And I don't know if I got time to use my cell phone to call the authorities. I don't know what I got time to do. Do I have time to get out of my car and start running? Whatever do I mean? I just don't see how it's helping me is what I'm getting at in that case. Maybe
Are there other questions of legal? Chairman Crawford.
Thank you, Madam Chairman. My question would be, the way the bill is set up and what we have discussed here, this would only affect people, even if they went and pulled a permit or whatever, we keep talking about blocking us in, but to me, this is talking more about blocking a highway, blocking a road, not so much sticking people in a garage. If you are on your way and there are people blocking your right of way, if you show due care, then they are violating the law. That would protect the driver of the vehicle. Correct?
Mr. Hayes.
Just 1 second for me to look at the language of the actual statute here. Okay, the bill in section 2 states that a person operating a motor vehicle who is exercising due care and unintentionally causes injury or death to another person who is violating subsection A. And subsection A is basically where we are talking about someone who is obstructing a highway, sidewalk, aisle, hallway, access to an elevator. Then in that case, so long as they're exercising due care and, unintentionally causing injury or death, then they would be immune from prosecution. Yes.
Chairman Crawford.
Thank you, Madam Chair Lady. I think that cleared it up for me. Thank you.
Seeing no further questions, we're back in session. And Leader Gant, you're recognized on House Bill 513.
Thank you, Madam Chair. I just simply wanted to thank Representative Shaw for his support for this piece of, and very important piece of legislation.
Are there any other questions for the sponsor? Question has been called. We're voting on House Bill 513. All in favor, please signify by saying aye. Any opposed? If you'd like to be recorded as a no, please see the clerk, but the ayes have it, and House Bill 513 moves on to calendar and rules.
Okay, members, item number 74 on our calendar is House Bill 130 by Chair Lady Hazelwood. Chair Lady Hazelwood, you have a motion and a second. We have an amendment filed on this bill. It's drafting code 7755. We've got a motion and a second on the amendment. Chair Lady Hazelwood. Okay, question's been called on the amendment. Absent objection, we are voting to add the amendment onto the bill. All in favor say aye.
Aye.
Opposed? Ayes have it. Okay, Amendment 7755 is now on House Bill 130. Question's been called on the bill. Absent objections, then we are voting on House Bill 130, sending it to calendar and rules. All in favor say aye.
Aye.
Opposed? Ayes have it. House Bill 130 moves to calendar and rules.
Thank you, Chairman Baum. We're now on the last item on this calendar, and that's item number 77, House Bill 975 by Chairman Williams. Chairman Williams, you're recognized. Do we have a motion? We have a motion and a second. You're recognized.
Thank you, Madam Chair Lady. I also have an amendment drafting code 8023.
We have a motion and a second on the amendment. Questions been called on the amendment. All those in favor, please signify by saying aye. The ayes have it. I guess I should, any opportunity, give someone an opportunity to say no. Any no's? Hearing none. The ayes have it. Drafting code 8023 goes on the bill. Chairman Williams, you're recognized on the bill as amended.
Thank you, Chairman and members. This will allow for NASCAR to bring back its races to the historic fairgrounds of Motor Speedway in Davidson County. It authorized events at the Speedway in Davidson County to be included in the sales tax, local option sales tax, local seat privilege tax structures currently permitted in code. The revenue generated from this bill will allow the Metropolitan Board of Fair Commissioners to properly maintain and develop the Speedway for future purposes. Madam Chair, lady members, I'm happy to answer any questions.
The question has been called. Any objection? Seeing none, we're voting on House Bill 975. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 975 moves on to calendar and rules. Next, we'll be taking up the subcommittee calendar and the addendum. The first item on the calendar is House Bill 1522, Leader Gant, you're recognized.
Motion on the bill.
We have a motion and a second. We have an amendment on this bill, drafting code 8099.
Motion on the
We
amendment.
have a motion and a second on the amendment. Question has been called. We're voting on the amendment 008099. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. The amendment is attached. We're now back on the bill as amended. Leader Gant.
Thank you, Madam Chair. And what the amendment did is it just changed the ending date from 2025 to 2023. And members, what this legislation does is the Tennessee Invesco program was established by General Assembly in 2010 and was designed to increase flow of capital to innovative new companies in Tennessee in early stages of development. The return on investment for the state has been underwhelming, and the statutory end of the program is approaching. Statute requires ECD to liquidate the remaining investments starting December 31st of 2023, but does not adequately define the liquidation process. In short, this amendment, or what this legislation does now, is it encourages liquidation of the outstanding investments by the end of 2023, effectively ending the program without forcing a fire sale that would devalue the remaining investments. Under this plan, ECD estimates that the state's return could be up to about $24 million through the end of 2025, but we have revised it now to end in 2023 with the amendment that we just attached. So that's all I have, Madam Chair.
All right, Representative Freeman, you're recognized.
Thank you, Madam Chair. And sponsor, thank you for bringing this legislation. I know it's disappointing that we didn't do, the investments didn't pan out like we had thought, but I want to note that the amount of capital that our initial investment in these companies brought was about $750 million, created 3,000 jobs and 186 something different companies. So while our return on our investment wasn't there, we were the first dollars in, which allowed others. And while this program wasn't as successful as we had hoped, I hope we can work together to create another program that can invest in companies like this, because this is the type of entrepreneurship and creative problem solving that we're known for here. And so anyway, I look forward to working on that in the future. Thank you.
And Representative Freeman, I would just note that Launch Tennessee, a big part of their mission is to do just that. And they are they've been very good actually at raising capital and funding startup companies. So I think it's not that we're not funding those, it's just that this particular mechanism, as the sponsor said, the performance has been less than we had all hoped. So, and way back when I was in ECD, it was already apparent that it wasn't working as we would have liked for it to. So I think it's timely to bring this legislation. Are there any other questions? Leader Camper.
Thank you, Madam Chair. Mr. Sponsor, did your amendment require a report back to the General Assembly at all on any findings, or is this just setting up a process to close everything down?
Leader Gant.
No, Leader, I don't think, I'm pretty sure it does not.
Leader Camper.
Just the process of how we're going to close everything out and moving up to date, only two things we're doing. Okay.
Any further questions? Seeing none, we're voting on House Bill 1522. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1522 moves on to calendar and rules. Next, we're on House Bill 865 by Chairman Haston. Chairman Haston, you have a motion and a second, and you are recognized.
Thank you, Madam Chair. What this bill does is it makes it where a percentage increase approved by the General Assembly for the BEP instructional component would also result in a percentage increase in the same amount for the state salary schedule. With that, I'll be glad to answer any questions.
You've heard the sponsor's explanation, members. Any questions? Seeing none, we're voting on House Bill 865. Moving on to calendar and rules. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 865 moves on.
Thank you, Madam Chair,
Chairman
Committee.
Haston. The next item on our calendar is House Bill 1501 by Representative Cochran, who's also been very patiently waiting. So Representative Cochran, we applaud your patience. We have a motion and a second. We also, I believe, have an amendment on this bill. Representative Cochran, is that right?
That's correct, Madam Chairman. 8055.
We have a motion and a second on the amendment. All those in favor, please signify by saying aye. Any opposed? Amendment 8055 is hereby attached to the bill. And now, Representative Cochran, if you would please describe the bill as amended.
Thank you, Madam Chair. And yes, that amendment does make the bill. And essentially, this creates a pilot program for a school turnaround where it's alternative for the Achievement School District. Hopefully, gives more local buy-in and ends up being a better alternative for that ASD.
Members, you've heard the explanation. Are there questions? Seeing none, we're voting on House Bill 1501. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 1501, as amended, moves forward to calendar and rules.
Thank you, Chairman and Committee.
Representative Cochran.
Thank you.
We're on number 8 on our calendar. I'm sorry, we're on number 6 on our calendar. House Bill 1080 by Representative Sexton. Representative Sexton, you're recognized.
Thank you,
Motion
Madam
and a second.
Chair. Is it okay to present the bill from a seat?
It is.
What this
Unless
bill-
you want to get up and move, which I would love to do by now.
Yeah, probably. What this bill does is it creates a physician's assistants board. And currently PAs are the only medical care providers in the TCA Title 63 without their own board. And as more physician assistants enter the healthcare field and serve as primary care providers, the need for a board solely responsible for oversight of these professionals is critical to ensure quality patient care. This board would consist of 7 physician's assistant, 1 physician, and 1 consumer member. And currently the PAs are under the medical board's Committee on Physician's Assistants. But this would be able to create their own. It's a growing industry. Our community or our college in Harrogate puts out more doctors than any college in America. So it's a growing industry. It's really aimed at providing quality medical care in our rural areas. So I'm very excited about this, and I'll be glad to answer any questions.
You've heard the explanation. Are there questions? Seeing none, we're voting on House Bill 1080, moving on to calendar and rules. All those in favor, please signify by saying aye. Any opposed, like sign? The ayes have it. House Bill 1080 moves on to calendar and rules. That brings us to number 8 on this calendar, and that's House Bill 1102 by Representative Shaw. Representative Shaw, you have a motion and a second.
Thank you, Madam Chair. This is the Joseph Bill. It extends the eligibility for expungement to persons convicted of assaults and a person whose criminal conviction was eligible for judicial diversion at the time of the sentencing. And of course, that's pending all fines paid. It would increase local government revenue.
You've heard the
With
sponsor's
that-
explanation. Are there
Yes.
questions? Questions been called on the bill? Any objections? Seeing none, we're voting on House Bill 1102. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1102 moves on to calendar and rules. Next, we're on our addendum calendar, item 13. That's House Bill 1267 by Representative Gillespie. Representative Gillespie, you have a motion and a second, and you are recognized.
Thank you, Madam Chair and Committee. What this does is, under present law, the Board of Directors of the Tennessee Education Lottery enforce and supervise compliance with the laws and rules relating to sports wagering in the state. What this does, it will give the Sports Wagering Advisory Board sole authority over areas regarding online sports wagering in the state. and the Lottery Corporation Board is okay with this, and so is the administration. With that, I welcome any questions.
Are there questions of the sponsor? The question has been called on the bill. We're voting on House Bill 1267. Moving forward, all those in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1267 moves on to calendar and rules. That completes this calendar. Do we have any further business coming before the committee? Leader Lambert.
Thank you, Madam Chairman. And will this be the final meeting of this particular committee?
Leader Lambert, only the good Lord knows.
With that, Madam Chairman, I merely want to be the first of probably many to say you have done a phenomenal job of leading us through this year in passing a $32.6 billion budget last week, which was a phenomenal accomplishment. And we appreciate your leadership for our committee. We appreciate your service to this state, and we applaud your efforts. Thank you, Madam Chairman.
Thank you very much. Well, while we're in thank you mode, I want to thank a number of people. We have thanked some of our staff on the floor the other night, or day or whatever time we got to that. But I want to take this opportunity again to thank the person who sat to my right hand throughout this, Marina Tunich. We could not have done this without her work, that of Peter Muller, our budget analyst, and Joel Hayes, our able legal, and of course, Krista Karstner, who has made sure that the things that we're passing, that we know what they're going to cost and are able to account for that in our budget. In addition to that, we want to thank the folks at the Library and Archives. We want to thank our Sergeant at Arms who have kept decorum. Sometimes that could have been a little difficult with this rowdy group, but they did a great job. And I thanked my intern earlier today, but she's still hanging in with us. So Ava, thank you again for all your hard work. And a special shout out, my assistant, you've not seen a lot of her, but she has been behind the scenes working so hard. And I hope that you all have found it an easy process to get your amendments filed, to when you were filing appropriations amendments and all that, working with Taylor Aliff. I know she has done a yeoman's job, and I want to give a shout out and a hand clap to her, please. And we have a lot of folks that don't get recognition, but without them, we couldn't make this bus run. Our clerks, Nick Ranger, Mike Crutchfield, and Caroline Morkel, we thank you for your work. And a special shout out to the folks who have worked so hard to clean the mics and try and make sure that we are healthy and safe as we do our work here. So again, it takes a lot of people to get this job done. I want to thank Chairman Hicks for his incredibly able leadership. Chairman Williams for working through the appropriations in a little bit different way that I hope that you found beneficial and helpful. So Chairman Williams. And to my able Vice Chairman Baum, who has done a great job with the gavel. So, and if there's anyone I've missed, I do apologize. But again, and thank you all for this committee is a hardworking committee, and you have, for the most part, been incredibly dedicated and been here on time and sat throughout some lengthy sessions like we've had today. So again, I appreciate your work and look forward to working with you again come January if we don't get to come back here. Leader Gant.
Madam Chair, I just want to say Charles Sargent is looking down and he's very proud right now.
That makes me very happy. Thank you. Chairman Zachary, you are recognized.
Thank you, Madam Chair. Members, calendar and rules will meet at 3:45. Calendar and rules will meet at 3:45. I know we have session at 4, but Speaker Sexton and Speaker Pro Tem Marsh are on calendar and rules, so we can't start session without them. So we will go through calendar and rules until we finish working through our bills. Thank you, Madam Chair.
Thank you. We stand in recess.